Hello, everyone. I'm just trying to make sure I have everything set up correctly. Please let me know if the audio is not quite right, because I'm a noob. I'm not good at this. Normally, Brendan takes care of a lot of this, and he is not here. I'm on my own for the moment anyway. Audio sound good? Can everyone hear me? Okay. Loud and clear. Great. Great. Okay. So, I guess while we're waiting for this to go live, we'll chat about really anything. I wanted to check really quick to see if there's been any doc drops, because sometimes that happens. So what do you guys think? What are your predictions for this hearing? Part of me feels like this is gonna be a crap show. But I'm not sure. Yeah. Bill Thompson's gonna have a tantrum, most likely. Let's see. Okay. They're always a little bit late too, but I'm gonna sit here and refresh. We have about 10 minutes until, 10 minutes and, a few minutes because they're always late, like I said, but okay. Let's see. I'm just curious what the state's arguments are going to be regarding having these hearings closed. And Taylor's, hold on. I want to pull up that document really quick while we're waiting, actually, because their rebuttal to closing the hearings, I thought was something, which is why I think this hearing is going to be spicy. I think it's going to be intense, kind of like the survey one was. And considering the crazy doc drop that we just had, calling out the FBI, asking to unseal IGG, I don't know. Okay, so I got to figure out how to add this to the screen really quick. Okay. No, we don't want that. We want this for now. And then we want this. Okay, the objection. So this is what today is about, is figuring out if they are going to close the motion to compel hearing coming up. One of them we know is already determined to be closed. So it's Mr. Kohberger's right to a constitutional it's his constitutional right to a fair and public trial was the defense's argument. No reason exists to prevent him from a public pretrial proceeding. Proceeding to ensure fairness and access to the state's information. Further, the state has made no showing that the hearing should be closed under ICAR 32, which, remember, we heard Andrea Burkhart's argument. If you guys haven't checked out her Substack, she wrote a whole article about this before this objection came out, saying that the judge should not go through, like he shouldn't close the hearings. And that the state's argument using that ICAR 32 code was just not, there was no basis for it because it was about documents. And that it would be a First Amendment violation if the judge did close this hearing against the defendant's wishes. So there's no legitimate reason that a motion to compel discovery should be shielded from the public, which is funny considering Ann Taylor has been sealing these for so long now. Like in the beginning of this case, you guys remember we had a lot of them to where we could actually read them and get bits of information out of it. And now we don't really see much of anything because they're filing all of these under seal now. And the defense is doing that. But you have to remember here, this is Bryan Kohberger's trial. So I think if there's anybody who should have the right to dictate if something is sealed or not and have like more of a pull on that, it should be the defense. So they allege the process of sealing is being abused by the state and its law enforcement agents, including the FBI, to hide how discovery is being withheld in this case. Testimony and argument on information sought by Mr. Kohberger does not meet the narrow scope of what the state can shield from public view. Not only is there no authority to protect the FBI, interesting statement, other law enforcement agents, and the state in this matter, this request to deny Mr. Kohberger an open hearing is a clear violation of his right to a public trial. And they cite a bunch of cases. The state has failed to provide all the requested items that were asked for in the defense's supplemental request for discovery to support the charges against Mr. Kohberger. Thus, the defense has had to file its fourth and fifth motions to compel. It's interesting they word it like that. Do you guys find that interesting? They have failed to provide all the requested items that support the charges against Mr. Kohberger. That's an interesting way of phrasing it. I don't think that I've heard them phrase it that way before. It is not lost on Mr. Kohberger that the state is asking for a scheduling order to obtain information from the defense to be used in support of our motion to compel the state's discovery. However, Mr. Kohberger suggests a dual deadline for both the prosecution and defense to file notice of witnesses, exhibits, and expert reports or other evidence relied upon at the fourth and fifth motions to compel by May 7th. Response disclosures by both parties should be due by May 10th. Yeah, it's going to be spicy. This is going to be spicy. Like, based off this hearing, it's just, you know how for a while, like in the beginning of this case, we really saw a lot of contention, I feel like, between the defense and the state. You know, about the police training records, if you guys can remember those hearings, and Bill Thompson getting all flustered and throwing a tantrum. And then there for a while, it all kind of settled down. And we had this period where it almost felt like Anne and Bill were like sucking up to each other in a weird way and protecting each other. And it felt really strange. Like, why do they seem like they're on the same page all of a sudden? And now I feel like something has shifted again, where they're at odds again. They're not vibing very well, which I mean is typical. They're not really supposed to, right? They're enemies in, you know, the court of law like this. You know, they're fighting for their client. The state is fighting for a conviction. But I don't know. I just feel they're really saying a lot right there by saying that the state is abusing the process of sealing records and hearings to protect the FBI, essentially, and other law enforcement agents. That's essentially what they're saying. What is the defense going to bring to prove that? Are they going to make an argument of what the state is trying to hide and protect? Like, what are they trying to protect for law enforcement? What information are they alleging the state is shielding from our eyes to protect the FBI? And since this doesn't appear to have to do with IGG, because the IGG portion of their motion to compel hearings will be sealed, so I doubt that will be brought up very much, but it might be. It might be. Because it does appear that there have been things that have not been turned over to the defense that may or may not, but seem they would probably have evidence they exist regarding the IGG still, even now. I just think that I think this is going to possibly have something to do with cell phone data for sure. But we'll see. It's got to be one or the other or both. But let us not forget about that video that they still said they did not have. Remember, you guys, the video that was all cut up into pieces and the audio and the video were separated? Has that been turned over in its entirety yet? Yeah, Brendan has a lot of faith in the FBI. We've talked about, police corruption quite a bit. And we had a whole police corruption week when we were still doing like a lot of pre-recorded content, where we talked about Baltimore and the massive corruption that happened there. We talked about other cases in Idaho. We talked about Gary Tolson, an ISP officer that was involved in this case, who was also involved in the Dr. Moore case. And they say that he framed Dr. Moore, which I believe is true based off of all the court documents I've read. I do think that he framed him, or at least had a part in it. But we talked about all that, and I think that Brendan's argument has been this entire time, which I am inclined to agree with him. I'm not denying there's a possibility the FBI has been corrupt in this case. I think that possibility exists. However, I think mistakes could have been made too. It doesn't necessarily mean corruption. It could just be mistakes. And also, we have basically a proven history with ISP of corruption. If you look at the Dr. Moore case, and we brought up another case, which I can't remember the name right now. It happened in Coeur d'Alene with a young boy who was shot. There were some weird things in that, but no proven corruption. Just weird stuff that seems like it could be. It could be corruption. But with Gary Tolson's track record with the Dr. Moore and Dr. Drake case, and him being so involved in this case, being at the autopsies, taking evidence apparently from the autopsies that the defense had to request. I think that is a more likely scenario. Like, why would you go to an agency that you don't have any proof they were corrupt in any local cases, but you have proof that there's a corrupt ISP officer, essentially, who was involved in this case? So I think he's just thinking of it like, what's the most likely scenario? The FBI or Gary Tolson, possibly the ISP. And we're looking at the digging into the ISP for a while, and there's several issues that I've ran across with them, at their organization as a whole. Oh, come on, Judge. It's not popping up here yet. Hold on. We're just going to keep refreshing until it pops up. See, nothing. You might be a Thought Riot addict by now. Well, I mean, being addicted to thinking is probably a good thing, wouldn't you think? Well, yeah, it probably is a good thing. But this document, this is what this is going to be about. If you guys are just hopping on, that's what this hearing is going to be about. And we're just waiting. Oh, here we go. Here we go. Here, let me go ahead and turn it on and I'll get it fixed.
All right. Thank you very much. Please be seated. Good morning. Okay. On the record, please. Thank you. We are now on the record. This is State versus Bryan Kohberger, CR 2922-2805. Mr. Kohberger is here in the courtroom. He's represented by Ms. Taylor and Mr. Logsden. Also, Ms. Massett is participating remotely. For the state, we have Mr. Thompson, Ms. Jennings, Mr. Nye is participating remotely, and I don't see Ms. Beatty. So we have a few things just to sort out today. The first thing I want to talk about is whether or not this hearing should be sealed. What's your position, Ms. Taylor?
Your Honor, this hearing should not be sealed.
Okay. Mr. Thompson? Ms.
Well,
Jennings?
Your Honor, the state's prepared to do its argument today without actually talking about the specific request that we're trying to protect within the discovery request. And so as long as those specifics are not discussed or mentioned, then I think we can go forward with an open hearing today.
Okay. Are you comfortable with that, Ms. Taylor?
Well, what I'm not going to talk about is the content of the court's protected materials that we've asked for a sealed hearing for. What I'm prepared to talk about is why should we seal this particular motion to compel that's set to be heard, and how much else is in the public record, and why there's no compelling reason to seal that, and why that violates Mr. Kohberger's constitutional rights. So if I talk about things that are in the affidavit, and if I talk about things that we're seeking that the state wants to hide, I think that's fair game for the public to hear.
It's the challenge here is that both sides have agreed to seal all the discovery. There's a lot of stuff out there, and so I hope that you can both honor that at this point, because down the line, maybe some things do have to discuss. We need to discuss very specifically that maybe both sides don't want that out in the public, because it is a fair trial goal here. And if we start arguing about the case itself, the trial, and the evidence that you're gonna present, both sides, gets more complicated and may be prejudicial to one or the other. So I guess at this point, we'll keep this open, but be careful. I mean, I've read everything, so I know what's sort of out there and what you're concerned about. And some of those materials or potential evidence could be prejudicial to the state, or it could be prejudicial to Mr. Kohberger. So my job is to try to keep on a balance here, a neutral balance, where when we get to the trial, if we ever get there, that it'll be fair and will have been determined in advance. Okay, so keep it open today. If something comes up and we need to close it down for a period of time to discuss a particular situation, then we can do that. Okay, so it really, I think at this point, it's the state's motion to close the hearing completely on May 14th. I believe, I'm not incorrect, that you both have stipulated to closing May 16th, which is related to the IGP.
Your Honor, our position is that's the only part that should be closed, and that's because we want to talk about the content of the materials protected by the court's order, and so that one's appropriate to close.
Okay. Okay, I think I'm on the same page, but great. Okay, Ms. Jennings.
Thank you, Judge. So, Judge, the applicable authority today in determining whether or not we should close the May 14th hearing is Idaho Administrative Court Rule 32 and Idaho Code 74-124. Both contemplate balancing this public right to an open hearing versus the interests such as privacy, safety, and the right to a public trial or to a fair trial. In deciding whether or not to file the motion to close the hearing, the state weighed those interests and ultimately came down that the need to protect the privacy and the sensitive information and ultimately protect the state and defendant's right to a fair trial outweighs the right to an open hearing. Feel confident that when the court does this same balancing test, it'll come to the same conclusion. For the record, since the beginning of this case, attachments detailing the specific discovery request have been filed under seal. In line with this, on April 4th of 2024, just about a month ago, the state and defense filed a stipulated motion to file all future attachments under seal. Today, we're specifically discussing the defendant's fourth and fifth motion to compel discovery. Concurrent with the defendant's fourth motion to compel discovery, the defendant motioned the court that the details be filed under seal, citing Rule 32. Concurrent with the fifth motion to compel discovery, both parties stipulated to filing the details under seal, citing Rule 32 as well as Idaho Code 74-124. So the state followed course. We have filed all of our responses under seal and then filed this motion to close the hearing to discuss those previously sealed details. Now the defense is taking a contradictory position and asking the court to ignore all the previous filings. And this is just entirely inconsistent. To be clear, the state has nothing to hide. However, it's crucial that we protect, as we have been trying, the integrity of this case, and that we protect, ultimately, the right to a fair trial. So let's look at the factors. Balancing a public's right to an open hearing and the party's right to a fair trial. Let's go to the factors laid out by Rule 32 and Idaho Code 74-124. And when we do that, for defense's fourth motion to compel, Item 1, Subpart A, discusses federal grand jury materials. Those are exempt from disclosure by federal law, as well as Idaho Code 74-104, subsection 2. What they specify as subparts B through N. All of those items discuss evidence related to this investigation, of which disclosure would, 1, interfere with enforcement proceedings pursuant to 74-124, subsection A, deprive the defendant a right to a fair trial and the state, subject to 74-124, subsection B, and Rule 32, subsection E. And it would disclose investigative techniques or procedures which are exempt pursuant to 74-124 subsection E. For defense's fifth motion to compel, item 1, subparts A through J, all deal with the investigation. All would be exempt pursuant to the same authority just cited. Subparts K through M deal with the names of private citizens who were interviewed, and disclosure would constitute an unwarranted invasion of personal privacy, subject to 74-104 subsection C. It could contain intimate facts or statements of which would be highly objectionable to a reasonable person, exempt under Rule 32 I-2A, or invoke traditional legal concepts in the law of the right to a fair trial, invasion of privacy, under Rule 32 subsection 3. Subpart N through O is exempt under interfering with enforcement proceeding, depriving the defendant to a fair trial, as well as disclosing investigative techniques or procedures. Item 2, subpart A, names a private business and is exempt under the previously cited authority. Item 2, subpart B through L deals with the investigation, again exempt under 74-124A, subsection B and E, as well as Rule 32, subsection E. Item 3 names multiple private businesses. It's also exempt under the same subsection, 74-124A, B, E, C, as well as Rule 32-12A and 3. Subpart I deals with the investigation, exempt under those same authorities. Subpart J involves a private citizen, exempt under those same authorities. Subpart K through B deals with the investigation and is exempt under those same authorities. Item 4 deals with IGG information, which has been sealed and is under a protective order from the court protecting its disclosure. If the court decides to open this hearing to the public, the state defense will be discussing evidence without any context. This will undoubtedly fuel speculation, lead to assumptions and false narratives. The evidence discussed may not even be offered, and most of it likely will not be offered by either party at trial because it's either not relevant or material. The public will not have any means or context to be able to differentiate that. It is necessary to mitigate this by closing the hearing in order to preserve the right to a fair trial for both parties. The defendant does have a right to a public trial, but that does not mean the right to try this case in media. The defendant will get his day in court, and the public will have a right to see what evidence the state has. But that should be evidence that is admissible pursuant to the Idaho Rules of Evidence. Now is not the time for that. We ask the court to grant the state's motion to close the hearing regarding the defendant's fourth and fifth motion to compel discovery. Lastly, I ask you to issue a scheduling order for the parties to disclose witnesses, exhibits, expert reports, or any other evidence they plan on relying on for those hearings. Prior to the hearing, the state proposed May 3rd, and then a response to those by May 10th. And the state takes no issue with this being a dual deadline. Thank you.
Okay, thank you. May 3rd might be a little quick.
Well, Your Honor,
Tomorrow,
right, but our motion was filed over a week ago.
right.
So everyone's been on notice of what the state was asking for.
Thank you. Thank you, Ms. Daniel. Ms. Taylor?
Thank you, Judge. Our discovery requests have been filed for months, and they've gone unanswered too. So if we want to talk about being on notice for something, we can talk about that.
Can I just add, because I've read through all of the fourth and fifth, and it's, I mean, some of the information, it isn't, it seems anyway, I mean, it's hard to know, okay, but it seems like the state has provided and has responded to some of those requests, and some they're still waiting to get that information. So that's the impression I had. I don't know if you disagree with that or not.
I would say the court is maybe in part right, but there's a lot of other parts to those fourth and fifth, and the court's referring to our motions to compel, not discovery requests themselves, but they do reference a number of discovery requests that have been going out. And we can talk specifically about each of those items.
I prefer not to.
And which is fine. I'm prepared to talk about why this needs to not be a closed proceeding today. But I don't agree that the state is completely responsive here. So I think the court can read and see that they say, we'll get it when you get it. I think the court can read and see when they say, we're not going to offer it, so we're not going to get it. I think the court can read all of those things, and we'll talk in depth on the 14th about what they mean and some of the ins and outs that go into play with those. But there's a lot more than just meets the eye. With regard to the hearing on the 14th, the state directs the court to look at Idaho Court Administrative Rule 32 and Idaho Code Title 74. And those really talk about documents that the court can seal. And both really are in, if you look at them, they are to talk about openness of the court and public's right to have information and what things the court can shield from the public and what the public has a right to know. And when we're talking about documents, it's been brought up that we've filed a lot of documents under seal. We have. Those are documents that end up in the public record that thousands of people can read. And we filed those under seal for expediency and saying, this is exactly what we want from discovery. If the court looks at the documents, and the court can and probably has through the year and a half this case has been pending, there are a lot of names and specific bits of information in there. And so for expediency, we filed those under seal and for the reasons outlined in Idaho Court Administrative Rule 32. But what we're talking about now is a public hearing when the state has decided to not give us information or to drag their feet on giving us information. We're talking about a public hearing where we have a right to be in the public eye, a public hearing. Bryan's the one with the right. It's his Sixth Amendment right to have a public hearing. When the state wants to close a hearing, or any party, and the other party objects, which we do, the court is guided by case law in the state of Idaho and the backdrop of his Sixth Amendment right to a public trial in the United States Constitution and Article 1, Section 13 in the Idaho Constitution. So in the backdrop of that, the court is guided by case law. And the specific case, there's a couple of Idaho cases, State versus Kimbley and State versus Olivine, and they refer the court to Waller versus Georgia, and that is at 467 U.S. 39. And that puts forth the test that the court should look at when determining whether to close a hearing or leave it open and let it be a public hearing. And that the court has to find that there's an overriding interest that the hearing should be closed. In this case, in this hearing, that's not what's happening. The court would look at Bryan's rights here to a fair trial and balance that against the state's request to close the hearing. And we would want the court to consider this, that this isn't the state trying to protect Bryan's interests at all. He has the right to the public hearing. This is the state trying to protect what the state's doing. And the court should look back through the history of this case. This is our fourth and fifth motion to compel. Motions to compel 1, 2, and 3 were public. They were right out in the open with the public. The specific discovery requests were also sealed. So this has been a pattern to do things in the public. And now this one needs to be sealed. The court has to ask itself why. And the court should ask itself, what is the state trying to hide here? The things that we're seeking in these motions to compel are things that are outlined in the probable cause affidavit that has been public for a year and a half now, that has been offered to be shared far and wide. We're looking for things like videos that the state said they collected so that we don't look at things in a little vacuum. The state tells you not to take it out of context. That's what they're doing when they want us to do this in private and not let the state know about the full scope of the videos that are out there that they haven't given us. That is the state keeping things in a vacuum to control the public narrative. And that violates Mr. Kohberger's rights. That's what we want to prevent. This needs to be out in the open. Your Honor, I'll give you a couple of examples. The state filed last June its motion for protective order of the IgG materials. That motion was filed in public. It's on the public record. People can print that and read that and do all day long. And that had information that was negative about Mr. Kohberger in it. So that's out there in the public. But that order was to protect information, the IgG information, that they say details how the state got to Bryan in the first place. That's been sealed, that's fine, we respect that. But you have to question, why can we not talk about the things they're not giving us? Why can we not talk about the cell phone information, the tower information, the drive test information in a public arena? Why should Bryan have to have his case when he's asking for this information be done in a little vacuum where the state says what the public can hear and what the public can't hear? Another example of this, Your Honor, is with the video tape that they've relied a lot on in their probable cause affidavit that we've received different parts of. Part of the hearing on the 14th is to talk about the different parts of that video that we've received and how we need the whole context. This is the video that they say places this car near the residence. We've received little tiny pieces of that. And we think Bryan's right to a fair trial means the public needs to know that they've withheld the audio from a great portion of that, and that it starts a long time before the little clip that we've received. To do this in a vacuum, Judge, when documents are filed under seal, that's fine, those are documents, but this hearing needs to be in the public eye. For the court to allow the prosecutor to say, we need to keep this all private for a fair trial, really ignores the public nature of this case. It really ignores the fact that Bryan has been essentially convicted in the media. You don't have to read but a few articles to see how negative they are about him. He has a right to have this information withheld, brought out in public, so that people can see it's not this neat little package. So people can start to wonder if Bryan's innocent. Your Honor, Bryan is innocent. And he has an absolute Sixth Amendment right to have his hearings in public. We think if the court allows the state to shield the information and how they got their information and what they don't want us to have from the public, they're using his Sixth Amendment rights to hide behind. And that's just not what the court should allow. We strongly object to these kinds of things being closed.
Thank you, Ms. Taylor. You know, I don't know where to stop though. I mean, if we start pulling out all the potential evidence for the trial, before the trial, then does the state get to respond to that? And that's where does it start? I mean, or stop? It just is a roll of that. And so either side, okay, it sends to the public that it is not, you don't get the context. They don't have the context, the public. You have the context. You want more context. I get that. But it's really difficult to just open that up and talk about particular issues in the case without talking about the entirety of the case. And that's what trials are for. I mean, I totally understand that Mr. Kohberger has a constitutional right to a public trial, but having a hearing is not a trial. That's something different. And so that's why, that's where the balancing comes to, if you want to answer that.
I do, Judge. The Waller versus Georgia case is in the context of a motion to suppress. If the court starts closing hearings now, when the court hasn't closed the other motions to compel, what's the court going to do when it comes time for a motion to suppress? Those are coming. Many of them are coming. We want the hearings in public. The state has dropped bits of information with different filings they've made all throughout the way. This can't be done in private. It just can't.
I would say both sides have said in their motions or in their briefs that they've disclosed, certain things. And it's a change, see, that because both sides have agreed to seal a lot of these issues of evidence in the discovery. And so all of a sudden it just does feel like it's moving in a different direction. But I understand what you said. It's like, this isn't about discovery, this is about the hearing.
Your Honor, those are discovery documents, and there are things in there that the state's chosen to respond to. The state selected which things that we have to have a hearing about. And these are about things that are in the state's possession or control that we want them to give us, and we're asking you to order them to give us these items so that we can do our work, so we can complete our investigation. It's not any different at all. Sealing the documents, I think that needs to continue to happen. That there are a lot of names in those documents and requests for follow-up. We don't have to do that. I do think those are fine, and I think they're different because they're documents that are going to sit in the public record they're different than having a hearing of things that the parties haven't been able to resolve on their own that the court needs to resolve. Public has a right to see how its business is carried out. My interest is Bryan's right. But I would ask the court to remember the history. We've had motions to compel 1, 2, and 3 in the public eye. All of a sudden we get to 4 and 5, and we understand the subpart of 5 that has to be in a sealed proceeding. That is going to directly deal with documents the court has ordered be protected. That's completely different than when the state won't give us bits of information that's within their possession and control that we need to prepare our case. Your Honor, I would ask the court to consider too how much pressure there is to get to trial. We've heard the state say they'd be ready by this summer. We've heard the state say they're going to be ready by March of 2025. We've heard them say that they've given us 95% of discovery. We've heard them say they've given us all of the discovery, and those things just aren't true. They're just not true. You can see from the list of things we don't have, there's no way we have 95% of it. So when there's all of that in the public eye and the pressure of let's get to trial, I think the public has a right to see, and Bryan has a right for the public to see that we're trying the best that we can. The court offered to do what it could to speed this up. Having hearings about things that shouldn't be closed, that we object to being closed, takes time. There is no change in our habit or our practice filing documents under seal for things that meet Idaho Court Administrative Rule 32 subsection I, and us asking for a public hearing. There's nothing inconsistent about that, and that's the way we've carried out the case.
Thank you, Ms. Taylor. Response, Ms. Jennings?
Yes, Your Honor. Ms. Taylor's argument and multiple completely false narratives are the exact reason why this hearing should be closed. Yes, defense has a right to a public trial, but that is not the right to having all hearings open to the public. The court's right. There will be a day for this, and that is the trial. But we shouldn't be discussing all the evidence that we're going to hear at trial prior to that. There's no right to try this case in the media. The case law that the defense relies upon has not extended this balancing test to these types of hearings. The hearings are about, or the cases are about trial. And yes, they extended it to a suppression hearing, which was so interrelated to the trial. Waller v. Georgia primarily stands for the proposition that any closure gives you this balancing test. We just went through the balancing test, and the state gave you the reasons for why this meets the test for closing the hearing. As far as being inconsistent, I would just note for the record, we have had one hearing regarding motions to compel. However, at that hearing, this is your order. At the outset of the hearing, the parties informed the court they had reached agreements on all issues except request 160. We discussed one request, and it had to do with training records. That is not what we're contemplating discussing at this hearing on the 14th. I've gone through the multiple issues and subparts, as well as the reasons why we cannot have this discussion in an open forum.
Thank you.
Want to respond to any on that, Ms. Taylor?
Well, Your Honor, we had the entire IGG state's motion for protective order and our objection to that in a public forum as well. That ends up resulting in us receiving documents that the court had a protective order on, and we can't even share with our investigators that come to court with us. And we've abided by that, and we understand that. But the entire hearing leading up to that was done in the public eye. In that particular hearing, they talked a lot about DNA results on a knife sheet. That I'm sure benefited the state to have that in the public eye. What we're going to talk about on the 14th, Judge, I don't have to name any private citizen names. I can talk about records that exist and why we should have them without naming private citizen names. I can talk about the videos that they've not given us. They're not about the business. They're about videos that were collected by the police. I can talk about those in the context of the police reports. And by the way, those are all things that are talked about in the probable cause affidavit. And I can talk a ton about the cell phone information, the cell tower information, and the things that they have not given us, the drive test information, the verification of such.
That's the thing. I don't want to talk about those particularly. And I guess I'm reminded, okay, in your comment about the IDG, because once again, you know, I'm in this position where I have to make decisions blindly to some degree, and that's what the case with the IDG. I mean, I had to go through all of that information, and then I provided most of the information to you, okay, to the defense, so that you could evaluate that. I feel that the same way about all the, I mean, there's a lot of stuff, okay, that you're arguing about, and the state is arguing about, and I think it's complicated to just open that up. I think that, you know, maybe we could go through a closed hearing and then open up what you feel needs to be opened up. But I can't make that decision in the you know, abstract. So that's my worry, because I went through all this last night again, and I thought, how do we really fairly deal with each one of those issues? There are a lot of issues.
I agree with you. There are a lot of issues, Your Honor. I would ask you to look at the probable cause affidavit and read the parts where they talk about relying on FBI agents and the CAST report and different cell tower data. Your Honor, that stuff's in the public eye. Why can't I talk about what they refuse to give me in the public eye?
Well, one of the things that we want to talk about today is I just got motions for subpoenas, deuces take them to the FBI. I mean, it's really difficult to get information from the FBI. You know that, they know that, I know that. We have we have to jump through a bunch of hoops to get particular information from the FBI. That is not the state's issue, although maybe it should have happened 6 months ago.
That's the state's issue.
I understand that. But that is one of the things that, I mean, we can maybe address that today too. I don't think, I'm thinking that you don't have an objection for me to sign the subpoenas.
No, Your Honor, I don't have an objection for the court to sign the subpoenas to try to get the information.
So I
That
can
doesn't-
sign that, I can sign
You
that
can,
today.
you can sign that. You can sign that. Anything you need to sign to get us the things we want, please sign.
I'm with you. I'm
That-
trying to do that. And, you know,
But-
from what I've seen, I mean, I think the state is trying to do that. I know that it's not satisfactory from your position. But
And
there's
those-
there's a lot of issues in this case.
And Your Honor, that's really a lot of what we're going to talk about on the 14th is the timing of these things,
Right.
not the full content of what we think these things might show. We don't know. We don't have them. They know.
Likewise.
So I think the timing is important. Your Honor knows how much pressure there is to get this case to trial, and Your Honor also is aware of all the things that we have to do. And when we make a request and months later, you're asked to sign the order so that maybe we can finally get that information, that timing part is important for the public to know. That's not the content. I'm not going to talk about the content of that subpoena you just brought up. I don't need to talk about that at all. But I can talk about the delay in this and why there's a delay in us being ready for trial. That is fair game for the public, and that is something Bryan has an interest in having public. So I don't have to talk about that content. That's not the issue at all. But the things that are laid out in the probable cause affidavit that has been on the court's public website for 1.5 years now, it makes no sense that I can't ask for those things in the public when they're things that the state said they relied on. That just makes no sense. I have one more ask when we're done with this issue.
Okay, thank you. I mean, are you expecting to make a decision right now? Maybe not.
Well, Judge, you should just make the decision to have the hearing open. And if I start to talk about content, then maybe you can talk about it then. I don't agree any part of it should be closed. I don't agree any part of the hearing should be closed. And I think you should make the decision now. We're 2 weeks away from this hearing.
Oh, 2 weeks, is that right? 14 days?
We're less than 2 weeks. We're 12 days.
All right, well, I kind of mentioned this a moment ago. I just feel like we need to get into the details, okay, of all these issues before I open it up. So I'm gonna close that hearing. Now, that doesn't mean that after we sort out all of those issues and I have more understanding of why you aren't getting what you want or what you asked for, or whether or not there is something that you've asked for that doesn't exist, or that some of the materials are holding with the FBI, and that we need to get that. I mean, those are all really complicated processes. And I would feel much more comfortable when, again, I'm trying to protect a fair public trial and not have a maybe not intentional unfair hearing, okay, that goes out to the public. I think that's the balance for me. That I want to see what all the issues are, the arguments from both sides, so that I can make a more informed decision. So I'm going to close the hearing. At some point in that hearing, maybe we can open up part of it. But I need to dig in, and you all need to dig in to exactly what is the problem with each one of these issues. All right, so, let's talk about the schedule. Okay, the state asked for this, some disclosures of witnesses, expert witnesses, exhibits by May 3rd. I don't think that's particularly practical at this moment. I know that you had, and I'm not looking at it right now, you had another idea about that, Ms. Taylor?
Judge, I think I had May 7th.
Okay. That seems more practical. Okay, so I will add in put an order out, schedule order for providing. I don't know if the state really knows what you do until you see what they have. And you're shaking your head, yes.
Yes, sir.
And that means that maybe you don't have any witnesses, expert reports, or exhibits at this point because you don't know what to expect.
Correct.
And this is related to the hearing on the 16th, right?
In the 14th, I'm not sure.
Okay. And there may be witnesses on the 14th too, as well?
Yes, Your Honor.
Okay. All right, so let's make it May 7th. For disclosing witnesses, expert reports, and exhibits. We'll see what the state has to do with that. And we'll have a response maybe May 10. Is that sufficient?
Okay.
It's tight.
Well, that gives us 3 days to respond.
3 days. Yeah, that's right. Well, May 10 is I don't know when I'm gonna read all this stuff too, because it's 14th, so if I don't have it by the 10th, then, you're saying the 13th? I guess I can do that the night of the 13th. But also, the defense needs some space there too. And I don't think we want to push out that hearing. Can't do it by the 10th.
We have no idea what the defense plans
Right.
on doing, and that only gives us 3 days to read, comprehend, and respond.
We'll deal with it. We'll deal with the 13th then.
Yeah, I mean, we can try, and then if we
Okay.
need more time, we'll ask for more time.
It's just then on my end, you're looking at, I'm gonna have really more, I'm gonna need more time.
Your Honor, I don't expect reports. I expect to provide a witness list.
Okay,
I don't expect there to be reports.
exhibits,
There may be exhibits. I think there will be at least 2 or 3. I know some will be things that they've already given us in discovery, so they shouldn't be new and surprising.
okay. I mean, it's hard to have these tight, timeframes because we also have other things to do, but Mr. Thompson?
Your Honor, it's completely unfair and unacceptable for us to get a list of witnesses with no idea what they're going to testify about. The names witnesses don't mean much of anything. And unfortunately, we're having a pattern in this case of last minute disclosures of witnesses and PowerPoints and all sorts of things that frustrate Your Honor's ability to assess what's going on because it's brand new to you, just like it's brand new to us. And I think that practice has to stop. We need substantive disclosures. If they're offering experts, the rules of discovery specify what you have to disclose regarding an expert, and that's not just a name. So what's being propounded by the defendant right now simply isn't within the rule. It's not appropriate. It's not fair to the court or to the state.
Okay, well, I mean, you don't have to have witnesses or exhibits, but you can have a response to say, well, this isn't fair, or whatever you want to say. Otherwise, I just need to push out this hearing. I'm stuck.
I appreciate that, Judge, and I guess we've said it before, it is more important to do it right than to do it quickly if we have to have a trade-off here. And that includes fairness to everybody involved, including the court. And I would prefer that this not be kicked off, but we're realizing that we're 2 weeks, essentially 2 weeks or less away from these hearings, that apparently there are going to be a number of witnesses that nobody but the defendant knows who they're going to be and what they're going to try to say, and then we're expected to react in court. That's just simply not the way to operate an effective, efficient, fair process.
Well, let's explore this. I mean, how many witnesses are you expecting to have?
Your Honor, I'm expecting to have 2 on the 16th. At this point in time, I'm not expecting either one of them to write a report. I expect a couple of exhibits. Some will be things from the protected materials that the court allowed us to have already. There will probably be 1 or 2 other exhibits, maybe 2 that the state hasn't seen before. I can provide those. I intend to provide those. On the hearing on the 14th, I think there may be 2 witnesses on that hearing, 1 for sure, possibly a second. We haven't made that determination yet. If there is going to be any PowerPoint presentation, I will provide that to the state as well. If we have an expert who hasn't written a report, then we won't offer expert opinions. We'll offer opinions about why we know the discovery is available, why we know these items are available. The state knows full well what they have and what they're withholding from us. And that's, I mean, it's not going to be about what they're going to show. We don't know what they're going to show, but we know they exist.
Thank you. Well, I just want to have this hearing. I don't want to push it out. All I can say is do your best. I'll be fair about it. I'll give you more time to respond if you don't have that time. That's kind of where we are. And I just want to keep going. I mean, we got to get through all this discovery stuff so that we can get ready for the trial.
Well, and Judge, I do for the record need to clarify, the representations of the defense that we are intentionally withholding things that they're entitled to is just utter nonsense. We have strived, we are continuing every week to provide additional discovery. We have more discovery coming. We hope that much of what they felt they had to file a motion to compel on, instead of being patient and wait, because our discovery deadline isn't until September, that we'll have and be able to make that available between now and the hearings on the 14th. And there may very well be little, if anything, we have to fight about. Your Honor also noted there are some things that we simply do not have the power to access. And we have been trying consistently through cooperative efforts, as well as following the process with the federal government. They have been good partners, but they have their own rules to work with. This isn't the motions for the subpoenas ducis tecum isn't the first TUI process, and the court is aware. We've been pursuing TUI process for all types of information for months. So the characterization that we are just consciously withholding information to frustrate the defense is utter nonsense. That is not true. We will provide everything we can that is providable under the rules. If we disagree on something, whether it exists or not, because I can tell you, many of the things that the defendant has tried to itemize, when we talk to our people, they say, that doesn't exist. So, I don't know what we're supposed to do at that point, and we'll flesh it out at a hearing. And it may be that if they have experts who are going to say, well, such and such should exist, we might have to go find experts to say, well, in this case, it doesn't. Or no, we'll see.
Well, that's exactly why I want to close it on the 14th, because we're going to have many arguments, apparently, about issue by issue by issue. And some of that should not be out of them.
Thank you, Your Honor.
Your Honor, I want to respond to that, and I could give you particular examples of things. And it's already been ordered to be given to us, the CAST report, which was a draft that we were promised to have by March 31st. It's May 2nd. We don't have it. So for the prosecutor to stand up and say that I'm misrepresenting things, he's misrepresenting things, Your Honor.
Oh,
That's
You know
there.
what, let's not go there. I mean, we can sort that out on the 14th. I mean, I read everything. That's what the state was saying. I trust both of you, okay, your integrity. So I don't want this pointing the fingers back and forth. I don't think it's very helpful. Doesn't really help me. You know, it started at the last hearing, and I really want you all to just tone it down a little bit. I mean, you can argue all you want, but when it starts to be personal, it's destructive. I mean, you're really, really good lawyers. So let's just focus on the issues. That's
Your Honor, we're happy to, and when we get the cash report, we'll disclose it. If we do not have it, we are not withholding.
I
As simple as
I
that.
read that last night. Okay. I'm fairly prepared about what the issues are, okay, about the discovery. And that's why I want to be able to hear from both sides, okay, what is the problem with this? What do we need to go forward? And I'm going to try and help that. And I expect that both of you do the same.
Your Honor, I do have several other examples, but in light of what the court said, I won't provide them right at the moment. There are other issues.
I understand, and I understand your frustration. And it's a big deal. It's
It is a
really
big deal.
important. I understand that too, and I acknowledge that. Sometimes, you know, we just can't quite get what we want from other people who might have it that don't want to give it up. So that's one of my challenges on the 14th and probably at the 16th too. Okay. Moving on. We've got all right, some of these pending motions, there was no request or no response from the state. And I'm thinking that the motion to unseal parts of the IGP materials and motion to allow defense investigators to review the IDD materials, that we're going to be addressing that on the 16th. Is that,
Yes, sir.
that's the state's understanding, Ms. Taylor?
Yes, Your Honor. Well, we're happy to have a hearing on the 16th for both of those issues as well.
Great. I'm just trying to make sure that we're all on the same page, or at least the same date. But I wondered, okay, there's been a response on the alibi issue, and I don't know if there is a request for a hearing, or if we just kind of let that lie for now. I don't know. What was your intention there, Mr. Thompson?
I think at some point we're gonna need a hearing on it. We're busy enough for the next couple of weeks with these other hearings, so we haven't reached out specifically on that.
Okay.
If the court would like to select a date while we're together today for a hearing, we would be happy to.
Why don't we just
Pick
wait
that
until the 14th or 16th?
That's fine.
And there may be issues that come out of discovery that have some bearing on that issue. I don't know. You don't have to say anything this day. It can read your mind sometime, maybe not. All right. Okay, I'm going to sign those subpoena duces taken. The FBI. I believe that's related also to the 13th supplemental. Maybe I'm kind of losing track.
Your Honor, it does,
Well, 13.
it does relate to one of our discovery requests, and I'm sure one of the numbered motions to compel. I'll note that when I speak about that on the court.
Okay, great. All right, are there any other issues that we need to address today? Mr. Thompson, Ms. Jennings? Okay, Ms. Taylor?
Yes, Your Honor.
Okay, go ahead.
I want to say this in a way that doesn't come off finger pointing, because it's not. This is about how busy everybody is and how much time it takes to communicate to get hearings set, because there's a lot of people going a lot of directions. I would like the court to consider setting hearings twice a month, every other week. And the court can vacate those hearings if neither party notices something up for that hearing. There would be 14 days notice for either party if we have hearings on that basis. But that way we could notice up specific hearings and just have those set dates, so that we're not bugging the prosecutor's office for a stipulation and bugging the clerk's office for a hearing and waiting to find that out. It would speed things up to have 2 times a month that we would know, if I've got 14 days before this hearing, I can notice it up and it can be heard by the court. So that's our request, is that the court just preset a couple of hearings. These would not be like the lengthy motions to suppress that we'll probably need a couple of full days for. These would be these shorter motions that we could deal with in 1 to 2 hours.
All right, thank you. I actually mentioned that, I don't know, one of our hearings. That's what we need to do. I think it would be more helpful to, I guess, have better communication, okay? I don't know, maybe you are having good communication with each side. It is hard, to get a hearing when the clerk has to contact you or contact Mr. Thompson, and this goes back and forth. I mean, it takes a lot of time for your assistant, the clerks. At the same time, I have a lot of other cases, and I have a lot of jury trials going from here really to the end of the year. So it's hard for me to say, okay, we're going to have it I think I offered Thursday, like a Thursday afternoon. So I'm willing to do that. I might just set like once a month, maybe, and then if you need something more, just let us know. But I'll look at my calendar and set that up. I mean, I know you come down on Thursdays generally. So that's a good day for you, right?
Thursdays are fine, Tuesdays are fine, Fridays are fine. Wednesdays are rough, but whatever day works for the court, I'll make that work. I just think it's more important that we have a place to put these hearings so that everybody's not spending a lot of time asking each other what day's okay, what time's okay, that we just all know that this is the time. So whatever day works best with the court schedule, Your Honor, is just fine with me.
Thursday afternoon is probably,
That'll work.
Monday is impossible. So what do you think about that, Ms. Jennings?
Yeah, that makes sense. I think Thursday afternoon would be fine for the state.
Do you think twice a month? It's probably gonna ramp up.
I suggested that just because then there's 14 days to the next hearing, so everybody would always have enough notice. This is why I suggested that, and to know that we have those to iron out issues that are going to arise. Again, these aren't for the motions to suppress, those will come later.
Okay. Maybe we'll start with twice a month to get through all this discovery. I mean, I hope we can all get past that soon. And move forward a little faster. Okay, anything else then?
No, thank you.
Okay. Okay, great. Well, thank you all, and have a good day. Beautiful day. Thank you.
Well, that was something, wasn't it? Oh, Brendan literally just walked in the door. Okay. Can you turn down your phone? I don't know if that's going to give feedback or not. That was something else. Like, it is confirmed we don't have a cast report. There is no cast report. And we called it. Okay, you coming to sit down? No cast. And yes, Ann Taylor again said Bryan is innocent. She said, Judge, Bryan is innocent. Did you catch the thing about the cell towers?
What? Everyone can hear us, right? We're good?
Yes.
We're good. Hello,
Everyone
everybody.
can hear us.
Yeah, I was watching the whole time. I just had to get the other studio checked out and everything. Yeah, I think this is massive. Like, this was
It was
huge,
a big deal.
But okay, and this is just my pessimism here. It makes me wonder, and look, I'm just trying to look at the situation completely unbiased from both sides, right? Are these things being brought up to help make the character assassination
level the playing field?
Yeah, to level the playing
look,
field. And I think both would be okay. I think it's okay if they are being brought up that way, because it's been so biased so far against Bryan. The only way that we're going to see is if this information is unfounded or not. And
you know why I don't think that is the case?
it's because she wanted it open, all of it open, so everyone would have been able to judge it for themselves.
She wants it completely open, and the judge acknowledged there's a lot of issues in this case.
Well,
he acknowledged it multiple times. He mentioned that, it's incredibly hard to get information from the FBI, and you can't always get what you want from people who don't want to turn it over, which makes me wonder, is the FBI not willing to do this cast report? Did they not do the drive test when they should have done the drive test? Did they not? Is there no cast report? Is there none?
Does everyone know what I'm gonna say?
No cast report.
I think that
it was pulled up right there.
I think that yeah, but I like being able to see it on this side, so that yeah. Anyways, look, there was a comment in there that we can't pretend wasn't said, okay? And that comment was that, yes, it's the FBI's fault, but the state should have requested the cast report earlier than 6 months ago.
Yes.
So how can we blame it on the FBI when we read in the cast report that the clarification, the drive test, and the peer review takes 9 months, and they've had this case for 2 years? So is it on the FBI?
Might not be.
I don't know if it is. Did the FBI even know that the state was going to ask for this?
Right.
Again, I don't think, and I was reading the comments, you guys, and stuff, and I saw some people saying, well, see how much of a role, and I'm saying this jokingly, I wasn't offended or anything, but how much of a role do you think the FBI had, Brendan, and things like that? I still don't see it. I have major concerns whether the FBI is involved in this or not. And that comment helps support that information, being that, look, the cast says very clear on public information that we had that the peer review and the verification process takes 9 months, I think is what it said. And I'll verify between now and tonight. And the state didn't ask for it until 6 months ago, but used it in the PCA?
No, they should have asked it for 6 months ago.
No, they didn't ask for it until 6 months ago.
No, they said the judge said Ann said it should have been asked for 6 months ago. One of them said it should have been asked for 6 months ago. And then Bill Thompson stood up and said they've been going through TUI, regulations or requests for months now. But
I don't know. The judge agreed with that statement that the
Yeah.
state failed on the cast report.
he did agree that they
Yeah.
failed.
So I don't think it was as simple as them just asking, listen, the cast information was included in the PCA, a long statement giving this presentation or comment about, you know, the cast officer's background and why it's so trustworthy and why it's so great, this, that, and the other. Okay, then how do you not have the evidence?
Yeah, I don't have as much faith in the FBI in this situation, mainly because we know the FBI was supposedly handling the IGG for, you know, the investigators, usurped it literally from their contracted laboratory, Othram. Their contracted laboratory for IGG for the state of Idaho is
At whose
Othram,
request?
and the FBI usurped it. I don't know. I don't know if there was a request. Also, we have heard that, you know, from the PCA that Payne and called particular attention to this. She said, Judge, I encourage you to look in the PCA where the state talks about relying on an FBI cast agent and, you know, the cell towers and stuff. And she's talking about Payne. She's talking about Payne claiming to have talked to a cast agent and doing this report himself, and that she only has a draft. And I think there's literally no cast report. And I think the possibility of why that could be is because I don't think the FBI ever agreed to do it.
So I agree with you exactly 100%. That's exactly what I'm getting at and why I'm saying that I don't think it falls on the FBI. Listen, I will be the first one to tell you the FBI does shady stuff, you guys.
No, I don't think Payne lied.
Not plural. The whole FBI does shady stuff. There have been situations and cases that we have covered, like that kid that was literally like fished, you know, baited into saying that he wanted to blow something up. And now he's serving his whole life in jail. And the one that was baiting him was the FBI. So trust me, I am not here to back the FBI because I have so much love for them. In this case, I do not see the fault on the FBI. I see the fault in the state. And this is what I am expecting to happen based on my experience in network technology is the state didn't request the FBI to do a drive test or request the cast report because they know once the network has been evolved and grown and fixed and towers added and towers updated, antennas updated, additional bandwidth put in that area, now they can't do the drive test. It's impossible. From the time that PCA was written, that network no longer exists. It is impossible to verify, okay? And then you have the state that only 6 months ago asked for the cast verification and information. Why? Because until it's requested, they don't do a drive test? You know what I mean? I think that they were betting on that information. I'm telling you. And now that drive test can't be used.
This is exactly what I mean. Thank you. That's exactly what I mean. Payne called an FBI agent and just got some tips, some pointers on how to locate somebody.
I agree.
And they was supposed to be an investigative lead. And it created a type of maybe cast report draft. They're calling it that, maybe a draft of a cast report is maybe the terminology they're using. However, I don't think it's a legitimate cast report, and I don't think the FBI ever did one, because that drive test would have had to have been done already. And it had to be done already.
Agreed.
And there's no way to go back and do that now.
I agree with you 100%.
So, as Brendan was just explaining. So I think there is a reason the state is holding that back. I think they're trying to figure out a way to fix it before they have to present information that they basically don't have.
Listen, I agree with you. And one thing that I was thinking about last night is and we'll put this out there for a poll for everyone. Do you guys think that these officers and the state truly believe Bryan is guilty? because that is something that's important to take into account and understand when you're looking at this case, because then the decisions of the prosecution make more sense why they're making flawed decisions and trying to pursue this investigation in a flawed way, because bias is scary. It's dangerous. It doesn't make sense. And all the decisions I see them making literally are not making sense. And this hearing, in my opinion, was way bigger than the last hearing. There wasn't the semantics. There wasn't the back and forth bickering until the very end. Bill Thompson was very clearly uncomfortable. I
Yes,
still
he was.
say you can literally see his face getting red
I
when
know.
Ann Taylor's talking. I'm not even joking.
I know.
It was like as red as my shirt, you guys.
Did you see when Brian sits there like this the whole time, and then when Bill got up and was like, you know, I have to say something, Brian was like, it just made me laugh. I was like, oh no. Because he sits there like a statue, like legit the whole time until
Yeah.
Bill started freaking out, and he was like, side eye.
I just have a feeling that the state and the prosecution truly believe Bryan Kohberger is guilty. And I think the change in Bill Thompson's behavior is Bill Thompson now becoming not so sure if Bryan Kohberger is guilty or not. And now Bill Thompson is trying to protect his career.
Yeah.
And I think Judge is picking up on it. And I think Judge is playing nice guy and allowing these hearings to be closed for that reason, because Ann's argument was spot on 100%. Judge should have opened up that hearing. There is absolutely no reason for that not to be closed.
I
There is
agree.
no reason.
He did it to protect Bill.
That's how it feels like to me.
Look,
the ITG is not the same as any of the other evidence,
No.
because any of that other evidence doesn't include other people's names.
It only includes, it's specifically the cell phone data. I won't say other evidence because there are other things they're talking about here that could. But I remember, you guys, before we hopped on here, I said, don't forget about the video. They've been talking about this video for a while that's cut up into pieces with audio separate, and they've only gotten these
With
little
this
pieces.
picture.
And then they brought it up, and I was like, I knew it. I knew that was going to be part of this. Where she literally said this is video that the state has been relying on to put Kohberger's car at the crime scene.
Yeah.
So we know that for sure now, that this is a video that they're using.
It's this one.
No, I don't think so.
I think so. I think that
this is from the footage that they lost, Brendan.
I know
this
that.
isn't in the neighborhood.
I know that. And I'm thinking that they're trying
I think it's 1112.
So you
footage.
think it's neighborhood footage?
I think it's a neighbor camera.
I think it's gas station footage. And
Okay.
I think they believe
I
that
don't think
this
so.
picture was Bryan Kohberger. And I think they believe that they're going to be able to pull evidence from footage in that general area at other gas stations. And that could be why it's clipped and pulled apart, because they're trying to show a history of the car driving from one side of the road to the other side of the road using multiple cameras. I'm just thinking from a technology standpoint here.
Okay, so that's not how I took it. How I take it is this is a neighborhood camera. And if you guys don't recall, the 1122 King Road neighborhood isn't very bright at night. It's pretty dark.
Mhm.
There's not street lights. And as you guys can also recall, if you've been paying attention to the Sebastian Rogers case, we have video footage from that neighborhood that they picked up nothing. Supposedly no cameras in the neighborhood picked up anything because there's no street lights and it's so dark at night. And we have one video we can look at and you can't see anything in the street. It is black out there. And while that's weird to me because I've never had a security camera be like that, I guess it's possible, so it makes me wonder, are they only seeing in the neighborhood footage like the whiteness of a car passing by? And you can't make out anything about it, really.
I don't know.
Are you just seeing reflection of light of a car passing by and you can't even really tell what type of car it is? It's just a white sedan.
Yeah.
Is it that dark?
I think very possibly it is that dark. Now, I don't know. I'm not I don't know 100%. I need to think on that. I need to chew on that because I think that's a very good and real possibility. But
yeah, I think it is a possibility. It just makes me wonder. And I think that the possibility, so we know that in the PCA, it says that Bryan Kohberger supposedly, okay, suspect vehicle 1, we'll say that, suspect vehicle 1, supposedly was doing these loops around the neighborhood, right? That's what's in the PCA. Well, are they looking at one camera? Just one, maybe. And that's that 1112 King Road camera from next door. And the pieces of the video are, it's a ring cam. So it's picking up when it goes this way. It's picking up when it goes that way.
Okay, now I get it.
It's picking up when he's turning around in the middle of the road. And that's why it's in pieces.
That is a good call out.
Yeah.
Yeah.
So that's what I'm thinking, is it's a ring camera in the neighborhood, probably 1112. I don't know what direction that camera was facing. I think people have talked about it and looked into it before, but I'll have to refresh my memory on it.
I forgot.
It just makes me think that it's a ring camera picking him up, going through, and it's too dark to tell anything.
I forgot how quickly ring cameras cut up footage. I totally forgot about that. And they're quicker than most cameras. Like they create smaller bits of video than most cameras do. So yeah, I think that's a really good bit of information, not to mention that we have 100% proof that there were 2 other white Hyundai Elantras in that area. Confirmed owners in that area, therefore making video evidence that would prove that he's there not so reliable. I don't think we shouted out the super chat.
No, but I did put it on screen. And thank you for that super chat. Mary, hold on. Brendan's sharing things. So yes, Mary, so Ann Taylor, proved indictment should have been thrown out. I agree with you. I do think they should have went back to a preliminary hearing. Considering all of these issues. And I think that was a big highlight of today, is that the judge is acknowledging there's a lot of problems in this case. There's a lot of problems getting discovery. There's a lot of problems getting expert reports.
Let's see what I said. I wrote something talking about that complaint. Let me see here. So I put, hang on. Let me see. Oh gosh, I have so many notes here. I don't know if I'm going to be able to find it.
Okay.
But what I said, what I sent to myself was that, all we hear all the time, and we hear it all the time, you guys, is how hard this trial is, how tough this trial is, how many different pieces that make it a struggle, that make it tougher than all these other kinds of trials. Listen, like, I don't know about you guys, okay, but I'm the type of person, and it probably has to do with my obsession and ADD and things like that. But when something's hard, you just get to it. You put your feet on the ground and you just do it. I feel like we see more complaining about how in-depth, how hard, how many things they have to struggle with in this trial, more than they're actually getting things done. And I've now felt that. I felt like it last hearing, but this hearing how many different times they've said it, I was like, dude, when is everybody gonna stop talking about how hard this trial is and start getting on with the trial? You know what I mean? Mm-hmm. And another thing that I've got to say in that same line of thinking is, Judge made the argument here that, listen, there's a time and a place for this evidence to be out, and that's at trial. We are at trial right now. We're going through the trial motions to get to including the jury members. But this is part of This is considered part of the trial.
The trial process. It is not part of the trial. It is pre-trial.
When you look up the definition of a trial, it talks about the pre-trial process.
Yeah, of course.
Okay, so then that still applies.
Yeah, but they're concerned
Bryan's
with
rights,
biasing the jury. They're concerned with biasing the jury
But-
before the
and that's
trial
Ann
and the jury
Taylor's-
is seated.
and that's Ann Taylor's argument that I want to back up, that if we have evidence, okay, that is actual evidence, like the cast report, like the DNA information, like videos and pictures, that can't be biased because that can't be changed.
Yeah,
So there are certain types of evidence that you can share in this pretrial portion that is not going to bias anybody because it's not arguable.
sure. And I'm not, you guys, when I'm talking about the camera, I know it's not a Ring camera. I'm saying Ring camera because I feel like people will identify with what that is. I believe people have pulled up the type of camera that light bulb cam is, and that it is like kind of a cheap Chinese knockoff, which is not great. That's
Mhm.
not great when using it for evidence in court. It makes me even more concerned. It might not have, night vision. It might not have a great picture. It might, you might have issues transferring the video footage from that camera over to computers and, using it as discovery. I just see potential issues with that camera
I agree
and
with
getting
you.
good
I agree.
evidence from it.
One thing that I just hope, you guys, is I hope that Judge has the confidence, if there's enough evidence in here that proves enough doubt, that Judge has the capability and confidence to step up to Bill Thompson and be like, yo, you need to check this. I am not going to spend any more of Idaho's money. We aren't going to do this any longer. It needs to be thrown out. And understand, I'm saying that because I see problems in the investigation, not because I'm a pro-burger. Okay. I am not here to prove Bryan Kohberger is innocent. What I am concerned about is the investigation, which we say over and over and over and over and over again.
Yep.
You know what's interesting?
We see
I just wanna
issues in
call
the
this out,
investigation.
okay.
What?
Is I didn't see any other creator say this except for myself, and a lot of our viewers ripped me apart for it. But the last hearing, do you remember me saying that it's a bad look for Ann Taylor to stand up and point fingers at the judge and other people? And then she stands up in court today and says, I want to be careful how I present this because I don't want it to seem like I'm pointing fingers at everybody. I was like, somebody's watching our show.
Maybe.
I just thought it was funny. Probably a coincidence.
Mary, thank you again for the $5 super chat. She said, what evidence did the grand jury see? And I have the same question.
We
What
know what it
evidence
is.
did they see?
Yeah. So remember, Ann Taylor 4 hearings ago made a statement talking about the grand I'm sorry, it wasn't Ann Taylor, it was Jay Logsdon. So 4 hearings ago, Jay Logsdon talked about how the grand jury leaned primarily on the eyewitness statements. So the grand jury made the determination based off of eyewitness statements. So assuming that we know who that is, right? Dylan Mortensen. And I don't know if Bethany Funk made a statement there or not. Do you know if she did? I know that she was attempted to.
She was
be
interviewed.
ordered to.
She was interviewed.
Okay.
But I don't know that she actually was there in court. I'm not 100% sure.
Okay.
It's secret. Look, it's sealed. We don't know. There's no way to know for 100% sure.
Oh,
There's
hey, Andrew Myers.
been
sorry.
some statements made. So the law offices of Andrew D. Myers, thank you for being here. I know you're a content creator.
Yeah,
Love
check
your
him out.
show. Check him out. And he said, I think the public and the victims' families are tired of all the sealing and secrecy and wondering why they're hiding the process. I agree with you. I mean, I think it's pretty clear the Goncalves family is tired of the secrecy and the delays. And, I feel for them. I truly do. I think this process is got to be extremely difficult and heart-wrenching, if I'm being 100% honest.
And here's his content, you guys. I'm going to copy and paste the link in our chat here.
But we
super
have
happy
to
have you.
At the same time, I think that we have to be reasonable and understand that Bryan has the right to a fair trial. Things have to be done the right way. I mean, hopefully the first time. Also, I don't understand. I think the sealing, I mean, look, Ann Taylor's last motion about this, okay, her objection to the state wanting to close the hearing, I pulled it up before the hearing and read it again because it's what today was about. And I made my predictions on what I thought this was going to be about. And it was about all of those things. It was about all of it. The video, the cast report, all of it. So in it, she's literally directly calling out the state for hiding things, sealing things, abusing their power of sealing things to protect the FBI and other law enforcement agencies.
I didn't get that.
That's what it says.
It says to protect the FBI or to protect their own case? Because today she did not say to protect the FBI. Today
I'm talking about the motion.
Okay.
Not what she said.
Today she specifically pointed a finger at the state and said that they are intentionally withholding evidence and information to protect the integrity of, to protect their angle of their case.
So the process of sealing is being abused by the state and its law enforcement agents, including the FBI, to hide how discovery is being withheld in this case. Testimony and argument on information sought by Mr. Kohberger does not meet the narrow scope of what the state can shield from public view. Not only is there no authority to protect the FBI, other law enforcement agents, and the state in this matter, this request to deny Mr. Kohberger an open hearing is a clear violation of his right to a public trial.
Okay. Yeah, I hear you. I just don't believe that's what it's about. I don't think it has anything to do with the FBI. I do not think the FBI has been at the beck and call of this.
So how do you interpret
at
that?
all. I interpret that statement as a good faith argument giving the state an out. Okay. And I read today's statements in court as the defense getting frustrated and now coming aggressively.
Yeah, they are.
Because the last two hearings, Bill Thompson and Ann Taylor have been very nice with each other, okay? Even going so far as to say, Judge, I know it's not Bill Thompson's fault, okay? I know it's not his fault. And then today, the gloves came off and she absolutely said, it is the state's fault, and they are absolutely hiding things with the intention of protecting their angle in this case. That was said flat out.
Yeah, it essentially was.
Yeah, and you guys, I promise, I'm not trying to protect the FBI at all. In this case, I just think that we have drawn enough evidence and connection to whereas if we start putting blame on the FBI, we are taking blame away from the law enforcement officers that are employed by ISP and Moscow PD that deserve the blame in this situation, in my opinion. I personally believe there are two people to blame for all of it. I do. I don't really want to get into that because it'll go down the tin hat route.
I think the university has a role in it too. There's a role in Scott Green being involved with the police, with ISP being involved, and the corruption we've seen in past cases. I think there's some kind of connection there, if I'm being honest. But that's only speculation on my part. It's just weird.
Mine is speculation too. I just think that, listen, Scott Green, I'm assuming, based on his profession, is a salesman, meaning salespeople push boundaries, okay? That it's just that's how salespeople are built. That's how they're bred. They're going to push until they find the line where they can't push anymore. Okay. So what I would have expected to see from Scott Green is Scott Green asking to be in the war room, Scott Green asking to give suggestions in the investigation, Scott Green asking to do all of these things. I expect that from him because of the type of person he is. What I didn't expect is that law enforcement let him. They're the ones who gave the green light. Okay. That was not Scott Green's decision.
Yeah.
It was
they
law
allowed
enforcement's decision.
Yeah.
And they said, cool, come on in, bro. You know, fist bumps all around, baby. And it is what it is, you know?
Fist bumps all around.
Yeah.
Baby.
I would not be surprised if they were having the daily war room meetings, you know, shirts off, fist bumps. No, I'm just kidding. Totally joking. But yeah, I just don't see a lot of, I still, you guys, I'm sorry. I just don't see a lot of blame on the FBI. I'm sorry. I see that.
You don't have to keep explaining how there's not blame on the FBI.
So I see that blaming the FBI gives these people an out. And that's part of the reason why I argue against it so hard.
What? Because you don't want the state and law enforcement agencies to have an out?
I don't. No, I think that, well,
so you're saying they're using the FBI as a scapegoat?
They are using the FBI as a scapegoat because the FBI will never be held accountable, you guys. They're feds, okay?
Look,
and they weren't the leaders in the investigation.
That's why I wanted to pull this up, because I feel like people were like, oh, the judge can, you know, demand that they turn things over. And that's not true.
No, the feds overruled.
I'm going to pull something up here in a second after we shout out the super chat.
The feds overruled the judge's decision.
Thank you, Danny. Thanks for the super chat. She said, love your pod. Great, insightful conversations. It would be great if you do a collab with Andrea Burkhart. Love from the UK.
I would love that.
Yeah.
Wow. Andrea Burkhart is incredible.
Yeah, we would love to do that if she would be willing to.
Yeah.
Anytime.
I see Andrea Burkhart like up here in experience and knowledge, and we're like down here, you know? But
she's the best.
She's just really good at what she does. And she presents an unbiased opinion in such a professional way.
She does.
That's what I strive to be, because I know that I present my ideas with bias, even though I try so hard not to. But it's part of the reason people think we are pro-boogers, pro Bryan Kohbergers, and
pro
support. It's why people think we support Bryan Kohberger and his innocence, because of our presentation. And that's the bias coming through, you know?
So this article is entitled Getting Uncle Sam to Talk, Obtaining Potentially Important Evidence from FBI for Use in Civil Proceedings. Obtaining information from a non-party for use at trial can lead to frustration and headaches for civil attorneys. And obviously this is in civil cases, but it speaks for the FBI, okay? Particularly if the sought after information is maintained by the FBI. Not surprisingly, the FBI does not simply turn over documents or provide witnesses for testimony when it receives a subpoena. So look, Judge is signing subpoenas today. Okay, he said it. He's signing the subpoenas for the FBI.
Yep.
But you guys, that doesn't necessarily mean it's going to be turned over. In fact, if served with only a subpoena, the FBI will reject it as improper. A party seeking such information must follow a certain request procedure established by case law and regulation, which is the TUI regulation process that they've been talking about.
So
if the FBI still denies the request, the party must initiate a separate action, or in some circumstances, file a motion. The process for seeking and obtaining records or testimony from the FBI requires navigating through a host of legal issues, including forum selection, standing, the Administrative Procedure Act, and the law enforcement privilege. This article summarizes the request process and guides the practitioner through the issues that may arise. Okay, so this is a really informative article, and it mentions TUI and all of that stuff, the TUI request process. You guys, it is incredibly difficult getting the FBI to turn things over. Even if they are subpoenaed, they can still just be like, I don't care. I don't care if you send me a subpoena. I don't have to give you nothing.
No, that is 100% the truth. Yeah, the feds do not have to bend over for the court in these situations. I agree 100%. And it's not going to surprise me that they don't. And again, this goes back to that I personally do not believe that's on the fault of the FBI. Where I feel like the fault lies in this is the fact that Officer Brett Payne decided to include cast evidence in the PCA. If you didn't have it, then you shouldn't have included it. And
exactly.
And I do think there was a cast agent in that area. And I think that all the FBI agents, all 60 of them, while it would be a nice idea to think that they were all there for the Idaho 4, they were there before the Idaho 4 crime happened. So ask ourselves why. Why were there so many agents and specialists in that area before the crime? Because they were working on the biggest bust that side, the Northwest,
Pacific Northwest.
Yeah, the Pacific Northwest has ever seen. And not only one, but they did 3 of the biggest busts back to back to back to back. The feds were in the area, okay? So how easy would it be when the feds are reaching out to local police to get information on this drug situation? Would it be to be one of those officers and say, hey, I know you're the cast dude. I know you're the cell phone guy. I know you're the network guy. Hey, can you just take a look at this number for me and your software and your information and let me know what you see? Sure, I'll give you a call back. The officer calls back and says, yeah, I see him. He's actually not in the area, during the time of the crime, but I see that he's at least in the area 12 times before the crime. And that leads into what we see in the PCA. Like, I just feel like that's what we're seeing. And I feel like they made a very big bet here on Bryan Kohberger. And I don't think the bet they made on their current story within the mainstream media narrative is going to hold water. That's my concern. That's my worry. I have no idea if Bryan Kohberger was involved or not, okay? There's a lot of different reasons why I think he could be involved. But I don't believe he was involved in the way that we currently see the mainstream narrative.
Yeah, I mean, I think he could be too, but I agree. The mainstream narrative with basically the narrative the PCA put out, I don't think is possible. And thank you, K-Shaw, for the super sticker. We very much appreciate that support. But yeah. So the drive test, you guys, that was mentioned, and somebody just asked in the chat, what is the drive test? Well, that is the cast agents, okay? You remember, Ann Taylor said they have to cast report draft. What is cast? Cellular analysis team for the FBI. They're the ones who do, tracking through geo-blended data, cell tower triangulation, GPS, all kinds of things, background application data. They are very good and have a whole procedure they follow for tracking somebody, which in the PCA, Brett Payne claimed he talked to a cast agent and found all this information on Bryan Kohberger that he, went to the crime scene 12 times before the crime, that his phone stopped connecting to the network, all that stuff we heard in the PCA. Well, to have an actual official cast report, they have to go do a drive test, meaning after they map all these plots and points of where they think Bryan Kohberger was, they have to go out and field test it with a device that is identical to Bryan Kohberger's device. That's the drive test. They have to go out and test it for themselves in the field themselves.
Did you call these out?
Yes, not the very last one.
Okay.
That one just came through.
Awesome. We appreciate
And
you.
Taylor is saying they didn't do that. And the thing about the drive test is it had to be done at least within 9 months? You said it had to be done within the first year of this crime and should have been done.
I think the
it has to
total
be done
process
ASAP.
The total
ASAP.
process. So that involves gathering the information, plotting the information on a map, a recreated map they make themselves, and then going back, drive testing, and then having all that data peer reviewed. I believe that cast report says it can take up to 9 months. Now, I don't know if they have a speedy version that they can, increase the speed on which they do it, but we can find out.
So that had to be done as soon as possible for it to be valid
Now
at
it's null
all,
and
to be
void.
scientifically valid, because the network has evolved and changed. There's constantly updates being done, which has been our argument from the beginning when we read the PCA and, Brendan saw the part about Payne saying he did the cast report and how this wasn't possible. This what he alleges in the PCA is just not possible when it comes to the cell phone. And that's where we saw the holes. That was the major thing that made us start questioning the case, because in the beginning we thought Bryan Kohberger was guilty. And then slowly, as we looked into DNA and everything, we're like, there's issues here. And funny enough, these are all the issues being brought up today right now.
They are. I'm telling you.
It is the cast report. It's the cell tower information. It's the video. And that's what's blowing my mind right now.
It's
is
not
the fact
about
that,
being right.
Look,
it's about
remember we did a poll
objectivity.
last night?
Yep.
And we said, what's going to be the evidence that convicts Bryan Kohberger? What's going to be the evidence to exonerate him?
Yep.
Like, what's the worst evidence and what's like the best evidence
for the defense to overcome?
So
what's going to be best?
We listed DNA.
Yep.
IgG DNA. We listed cell tower. We listed video and witness testimony, eyewitness. There are issues in all four of those categories. Big issues in all four of those categories that we're hearing about in this hearing. We're not hearing much about the witness, the eyewitness, but I think that's the least important. So, let me check these super chats. Mary said, what else in the PCA was inflated to support arrest? Ann Taylor has exposed the state today. I agree, Mary. And I think that things are being exposed. I mean, we've been digging into this case and researching everything that, like, those heavy hitters I just mentioned, the eyewitness. We did the interrogation room video where we talked about how, Dylan could be coerced into making specific statements. We talked about, how unreliable human memory is with the surveillance footage. There's oddities in the PCA about how he's being picked up on camera and where he's going. And then also, the camera quality is, I'm really questioning the camera quality now. We have Ann Taylor now coming out and talking about how it's cut up into pieces and they're not getting all of it turned over to them. And then we also now have the IgG. The IgG has been a big problem for a while. They have retained 4 experts. They have 3 now talking about the IgG specifically and the issues with that, and the cellular information. You guys, those are the main heavy hitters that would convict Bryan Kohberger. These are the things the jury will rely on in saying, do I want to put this man to death? Can they put him at that crime scene? Can they put him there? Those are all the things that could put him there, that all have major issues. Major. So I feel you, Mary. And thank you so much for gifting 10 memberships. That's incredible. I appreciate that so much. And I know Brendan does too. And welcome, Thought Riders. Please thank Mary for her generosity. And thank you, Evie. We appreciate you too. Thanks for being a member for 2 months. That's awesome. But yeah, I mean, let me look back at my notes because I know there's more I wanted that was blowing my mind during this. It really sucks that this hearing is going to be closed. And there's a part in here where, how we were just talking about how basically we think Judge Brendan mentioned this, and I agree. He's protecting the state by closing this hearing, essentially, to help him not look bad, help the state not look bad. There's a part in here where they cut off Ann Taylor from talking about the cast report. The state starts to object and the judge just cuts her off. And I was like, whoa. That was intense. They really did not want her to say that. She said something about the cast report, cell towers, the drive test, and then verification. And then they were just like, nope, quiet. Be quiet. So I find it interesting. So Bill Thompson said that essentially Ann Taylor is misrepresenting things and that they've been filing and going through these TUI regulations for months. He also said that the federal government has been a good partner. Have they been a good partner? Because if they're not giving you the cast report, I don't think I would be saying they've been a good partner. Didn't you think that was interesting? Because I know Brennan keeps saying that he thinks that they're going to try to pass this off as like a scapegoat, like they're going to make the FBI a scapegoat. But Bill Thompson wasn't doing that. He wasn't like, even though he said there's issues with getting it from the federal government, it's difficult. They have their own regulations. He didn't just like be like, oh, they are horrible. We can't get anything from them. Like he didn't cast any shade on them. He said essentially, they've been great buddies for us, you know. They just have their own process and we've been engaged in it for months. But the thing is, if it's so hard to get this cast report and get this information, then why was it ever used in the PCA to arrest Bryan Kohberger? Oh, that's okay, Anne. And thank you so much for being a member for 7 months. You're an OG thought writer, and you know we appreciate you.
Yes, indeed. What?
No worries. You can always catch up later.
What other notes did I write? Let me see.
I was just looking at my notes. It was
Hang
a
on
lot.
1
There was
second.
a lot of things mentioned in this. I feel like there was some big bombs dropped. And I just, dude, them not having the cast report, gosh. Why? If the state can't get their hands on it, why didn't they say this just so long ago? Like, you're better off saying, like, we can't get this information. It's not possible early on than, you know, leading everybody on for so long. So we know that, okay. So she said, I need this to be bigger. This is too small. You know, it was kind of funny also that the state thought them going through all of those codes and subsections was going to be enough for the judge to be like, oh, yeah, I agree with you. It's funny because I don't even think the judge agreed with their arguments necessarily for closing the hearing. He is just worried about making sure everybody stays friends and that the state doesn't look bad, which is something I have a major issue with. I don't believe it is judge's responsibility to keep the state from looking bad. How do you guys feel about that? Like, how do you feel about that? The fact that he is so concerned with making sure the state doesn't look bad. Because he said numerous times that if this information is discussed publicly in court in this hearing, that it could be prejudicial to either side. Meaning he's not just thinking about Bryan Kohberger, he's thinking about the state's reputation. That is literally what that means. Worrying about it being prejudicial to the state's reputation, like what else could that mean?
Okay, sorry guys. I'm still working right now.
So, did you hear the part where Judge said that if this information was discussed in open court, that it could be prejudicial to either side? That was towards the beginning. I don't know if you were watching yet.
I don't think I was watching.
Okay, so
yet.
in the beginning,
before Ann Taylor made her statement,
I think
when he was
so.
laying the premise of the hearing.
Yeah,
okay,
I think so. He said that it could be prejudicial to either side.
He did say that later. Also,
he did
an
say it
assumptive
numerous times. So
comment towards that.
Don't you think that literally means he's worried about the state's reputation? That's what that means.
So, short answer, yes. Long answer, this is a concern that we brought up over the last 3 hearings
That's a
that
problem.
they are using the information that we want to make sure it's fair for Bryan. We want to make sure that it's a fair trial. They're using that as opening statements to support things that are actually hiding the state's case. I think Ann Taylor finally got tired of that. And again, I'm not laying my flag on yes, 100% this is happening. However, the evidence from what we are seeing makes it seem like that could be happening, okay? Which is really interesting because, yeah, I do think it's a problem. And yeah, I do think that in order to have a fair trial, I personally believe that the defendant should have more say-so in how this trial is conducted in general. And the reason being is because the evidence should be what it is, right? If it's sound evidence, it's not biased evidence. It is objective evidence, and it's not going to change whether you say it today or you say it in 6 months from now. It's not going to change anything. What it feels like to me that they don't want to share it for reasons being that they don't want it to taint the already created character image of Bryan Kohberger. And yeah, that's a problem because that's bias.
Yeah, and Skylar said, well, if the state looks bad, it makes the judge look bad too. I don't agree with that. And here's why. I don't agree with that because the judge is not a part of the state. He is the mediator between the two. If one of them is doing something wrong, he's supposed to call them out. He's supposed to put them in their place. He's supposed to make sure that Bryan has a fair trial. And that the public is also getting justice. So his concern is the victim who the state represents and the defendant who is innocent until proven guilty. And if he becomes biased to either side, he looks bad. It's not about if the state looks bad, he looks bad. If he's biased towards the state and he's helping protect the state from their own mess ups, okay? If he's protecting their reputation, I think that looks really bad on him.
Yeah. And I agree with you.
I'll give him a chance, though. He said he might open up this hearing once they get through some things. I don't agree with him closing this hearing. It shouldn't have been closed, but he's trying to make sure everybody remains friends is what he's doing.
Yeah.
And is nice and everybody's cordial. He wants everybody to be respectful, which I'm not saying there's anything wrong with being respectful, but he made a comment in there like, oh, when you guys start getting personal, it was never personal. Calling out the other side's,
makes it personal,
dragging their feet is not personal.
What makes it personal is the tonality that they're presenting the evidence in. And I agree with Judge. I feel like that this case again is the first one in the last 3 where it has felt personal again. Because remember, I'm an advocate.
You thought this hearing felt personal?
Yeah, I'm an advocate that perception matters. It is really important, okay? Absolutely, really, 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 really important. Did they say anything personally attacking either one? No, they didn't say anything that was a personal attack, but the tone of how it was presented made it feel personal. And I think that's what Judge was picking up. And I think that's why Judge was like, hey, I need you guys to get along. Whether that was an acceptable thing to say is a completely other matter at hand here. However, I have supported this judge from the beginning. My one concern is the very same that it was in the beginning. Does this judge have the confidence to tell both the defense and the state when it's necessary to shut up? You guys need to listen. This is a zoo here, let's fix things. Let's get this moving in the right direction.
I'm afraid he can't put his foot down.
I'm worried about the foot down thing. And listen, I feel like a jerk even bringing it up because the world needs more nice people, okay? Not more jerks. And Judge, I think, is a really nice person. However, this is a very important case in the eyes of the world right now, especially the U.S. He's
a little too nice.
He has came off a little bit too nice, but I don't see any bad judgments as of yet, except this one I was a little surprised about because I think it should be up to Bryan whether this information is public or not. And what's even more interesting is everything is stacked against Bryan Kohberger right now, regardless whether he's innocent or guilty, you guys. The mainstream media constantly sends attacks out day after day after day saying Bryan Kohberger's a monster. I can't believe Ann Taylor is, supporting him, defending him in this way. That it's just a constant, nonstop, never-ending attack on Bryan Kohberger. And for Bryan Kohberger to be willing to take the risk and have that hearing live, where all that information is accessible to the mainstream media machine, in my opinion, says a lot. And I think that the defense should be the ones who have a say in that, not the state.
Yeah, I agree. And I also agree that they aren't following procedure, and everything in the courtroom does feel like an open conversation. Instead of the judge making the decisions, he's asking them what they think the decision should be. Which is interesting to me. He always throws it back at the state and the defense, like, well, what do you guys think it should be? Because I don't know what to do here. Like, that's how it feels, in my opinion. Also, I think that Ariel made a really good point, and that is that, remember Bill's argument about the alibi, that it took them this long to come out with it, and it should have been given to them a long time ago. It's not good enough, and then in this hearing, he said Ann Taylor should have just been patient and not filed a motion to compel, because the deadline is supposedly in September, which, the deadline for the cast report was not in September, Bill Thompson.
Yeah.
It was literally days ago, and you missed it.
Yeah.
So him saying she shouldn't have filed a fifth motion to compel, she should have just been patient. You are asking for the alibi and withholding the cast report, or the fact that there is not a cast report.
Yeah, and I think that is a big reason why that next hearing is going to be closed. Now, what's interesting here, though, is that in that same breath that you're talking about, did you hear Bill Thompson say, the way that we're handling this case by essentially what he was saying, I'm going to shorten what he said, is the defense is using trial by ambush techniques, by bringing up experts, by using presentations. He's still complaining about that from last hearing. But at the end of that statement,
the PowerPoint.
Yeah, at the end of that statement, he slides in there, and that is so frustrating for the judge, for your honor. And again, I was like, God, that drives me nuts.
Stop telling Judge how to feel.
Yeah,
he's like, you need to be frustrated.
That's such a petty thing that I'm bringing up, but it's frustrating because,
no, it's petty on his part.
Let Judge say how he's feeling about the case and the ruling and the things himself. That is insane to align yourself. The judge is supposed to be presented as unbiased. So why Bill Thompson is constantly trying to align himself with the judge is weird. It's just strange.
It's a manipulative to the judge. He's manipulating Judge.
Is he, or is he tanking this case because a judge has to remain unbiased? I don't know, man. And that statement that the judge's workload is really full, I've again got to be honest, it made me for a second feel like, is Judge going to try stepping down after they move this somewhere else? Is Judge going to step off this?
I thought he would follow the case, but now I'm not so sure, if I'm being honest. Right, Heather. It's frustrating to have experts in PowerPoints, right?
Yeah,
dude,
it's frustrating to know the truth. That darn truth.
Yeah, somebody said in the chat during the hearing, Bill Thompson has nightmares about PowerPoints. He probably does have nightmares about that PowerPoint. That's probably like when you're in front of the school with only your underwear on.
Yeah.
Like you're just on stage and only your undies. That whole dream, that's him with the PowerPoint. When his face comes up on the screen.
Someone needs to send Bill Thompson and the prosecution this statement right here, okay? Bill, you and your team need to be trained on how to public speak, how to present yourself, how to effectively grandstand and fill, you know, the gray matter in a conversation to make it sound good. You've got to be relatable. You've got to come off like a human being. Every time they object to anything or trying to argue out of anything, I've got to tell you, Anne is pretty dang good at it.
Yeah.
Pretty good at it. You
She
know?
is.
There are people that are better, but she is relatively good at it. Now, the prosecution, both of them were awful today. I wasn't sure if either of them were crying while they were talking.
Both the state?
Yes. The lady, I forget her name, and Bill Thompson, they both sounded like they were crying, their voice cracking, they were uncomfortable. I was like, oh, this is so awkward. What is going on here?
There was so many people. Actually, I saw numerous comments that were asking if she was crying and if Bill was crying.
Yeah.
You're not the only one. There was a whole bunch of people like, are they crying?
That's how it felt. I'm telling you, based on what I was hearing. And when I was listening to this, I was not watching it, you guys. I was only listening to it. So as I was listening, I was like, whoa, what is going on here? I legitimate, you know, when like a guy, it like gets into a fight or something in high school and they're trying not to cry and their voice is cracking, but you can tell they're crying a little bit, but trying to be strong and make a statement.
That's
like,
embarrassing.
That's how it felt. I felt like Bill Thompson was right on the verge of just like running to the restroom to cry. And I'm not saying that as an attack. I'm not trying to be a jerk. I'm trying to share why his statement in front of court and the world was not effective, because that a fake confidence in your presentation does not present as confidence. You've got to have confidence in your argument. You've got to believe in your argument. And maybe that's why we're seeing this. Maybe that belief in this investigation and case is gone. I don't know. I don't know. All I can do is speculate. All I can do is guess based on what I'm seeing from their behaviors in court, you know?
Mm-hmm.
But I haven't said it yet. I haven't said it yet because I don't believe in I told you so's. But just remember that this is the right place for an I told you so. I knew that they were talking about the cast report in Bryan Kohberger's alibi. I knew they didn't have the cast report. I knew it, man. I knew it. Otherwise, somebody like Ray isn't needed.
Yeah, I knew it too.
And this is finally confirmation today that they do not have it. It is not there, and that is what they were talking about in the alibi.
Well, we've been calling it literally from the moment we read the PCA. There's no cast report.
Yeah.
The PCA is confirmation there's no cast report.
Yeah. Wait, the PCA is confirmation there's no cast report?
The fact that Payne called a cast agent and did it over the phone. The fact that all of we've had tons of confirmation, even if it's not official.
I don't
we
know
got the official where it was said in black and white today that there isn't a cast report.
Well, no. Not that there isn't a cast report, that the defense hasn't been given the cast report. That what they were talking about in the alibi pertained to the cast report and not what was the other evidence
but do you realize
that experts were arguing about the alibi? They were saying that motion to compel in the alibi was in regards to something other than the cast report. But I always thought it had to do with the cast report because Bryan's alibi leans on cellular and network-based evidence. So I believe that last that last paragraph had to do with the cast report.
Okay. If the state doesn't have a cast report, the defense doesn't have a cast report, then there is no cast report.
So there is a cast report. And I think that was the argument Ann Taylor was making and why she's saying, Judge, the state does have this evidence. I can prove it to you and they are withholding it. What if there is and I'm not saying a complete cast. I guess let's clarify that. Okay. When I'm saying a cast report, what I'm talking about is not a plotted map that has gone through the proper reviews to be presented in court. That's not what I'm saying, you guys. When I'm saying, I should say there is cast science, okay? Cellular science using RTT time and plotting on a map.
We've already
That's what I'm
heard there's a
talking about.
draft. We've already heard there's a draft. That's all we got. That's all the state or Ann Taylor has. So that's all there is. To have an official cast report.
You're making a generalization.
No,
that we
I
don't
am
know.
not.
We
The
don't know the state doesn't have it.
So you're saying they could have the official report and
That's
just not
what
be
Ann's
turning it
saying.
over?
That's what Ann said.
Or the state just isn't willing to admit it doesn't exist.
No, listen, I don't know, but I just know what Ann said objectively. This is not opinion based. Ann said that they have evidence that they are intentionally not turning over, and Ann has the evidence to prove that's what they're doing. I can only assume, since cast report was talked in the same breath as that statement, that she's referencing cast data.
Yeah.
That's my assumption.
I just don't think a cast report was ever completed, and we know that it wasn't because they said it was undergoing peer review process, meaning there is no official finalized report. And that was said last hearing. There was no peer review. There's now the drive test. I don't know. Maybe that was done, but it hasn't been turned over.
They were waiting on peer review, and that's why they were supposed to get it on the 31st. Not that there's no peer review.
Yeah, they said that they were waiting on it.
Yeah, waiting on the peer review.
Meaning there's no finalized cast report. They were waiting on it. But it still hasn't been turned over.
Finalized cast report. That means that's what the state is claiming. That's a difference. And the only reason why I'm making that distinction is because we have Ann Taylor arguing the point in front of court that the state is intentionally withholding evidence. So I don't know what that means. I'm making the jump here, an assumption that she's talking about cast. Maybe there is a cast report. Maybe that cast report does not support Bryan Kohberger's guilt. Maybe that cast report does not support the angle that the prosecution is taking to convict Bryan Kohberger. And maybe that's why it hasn't been shared.
Well, if they are withholding it, then that is a Brady violation.
That's what Ann's saying. I'm not saying that. That's what was argued today in court.
Okay, well, if they're withholding it, the only reason they would be withholding it is because it looks bad on their case and it could potentially be exonerating, and that's Brady violation. They should be sanctioned.
I agree with you, but again, you got to prove it first.
Yes, that's true.
Ann can say all she wants, but I'm just being honest here. I don't want to make I don't want to make jumps and generalizations in this case because it is cluttered enough. Okay, I think it's important that we clarify what can and could happen in this case, and I think there's multiple options of what could be done here. I know the defense doesn't have the cast report. That's the only thing that I'm claiming my flag on, and that's what I claimed the other night. Is the reason why the alibi said that at the end is because the defense doesn't have the cast report, even though they were ordered to have the cast report by March 31st. And you know what else is interesting in regards to that?
It didn't get turned over.
If the state didn't have it, not that. If the state didn't have it, why were they not sharing that information? Why did they wait until they were compelled to give that information to then come out and be like, sorry, we just missed the expiration date on that? Like the state is acting like they have this whole thing put together. Let's put everything on the books. We're ready for summer. Oh, by the way, we can't get you all the discovery till after summer. Like it's a bunch of smoke and mirrors, in my opinion. Because in regards to the cast report, if they knew ahead of time if they didn't have that, okay, why wait until it got to the expiration date, making the defense feel like they can depend on that discovery to be handed over to then give their alibi? Or were they waiting on the alibi to then create a cast cellular-based evidence report?
Yeah, what they're accusing Bryan Kohberger's defense team of doing, claiming that they're waiting on discovery to fabricate an alibi, are they doing exactly that, but the opposite? Are they waiting on Bryan Kohberger's alibi so that they can then fabricate evidence to disprove his alibi and use against him. Yeah, it's concerning. I agree. Which is why I think this whole alibi thing that they have in Idaho is not a thing in other courts in other states, because it's ridiculous. I don't think the defense should have to show their hand ever.
If the state tried to go back and create a cast report now, the defense would rip it apart. And it wouldn't even take an expert to do so. All they would have to get is a dated map of the FCC's coverage areas from the time of the crime to now. That's all they would need. And you don't even need an expert to argue that. You just show the difference and why the data in the drive report. So imagine what the case would be like, you guys, if you take away any of that cellular info. Now all we have is trace DNA, which can be blown or transferred. It's transferable DNA on a sheath at the crime scene, and a video of a car that
apparently with no license plate. Yeah, no license plate.
That loses all of the character building personality traits that is being used to make it seem like we have an incel serial killer.
Dude, this is really scary and worrisome, if I'm being honest. It just really worries me. If Bryan Kohberger is guilty, they don't have the evidence to convict him. And if he's innocent, then the killer's still here somewhere.
I've felt that way.
Nobody's
for a while.
looking
It's
for
terrifying.
him. Nobody's looking for him.
Yep.
It worries me. And I can't say I'm surprised by anything that was even said in this hearing. I think a lot of it was honestly expected by a lot of us in the community who have been looking at this for a while. Like, this all makes sense, sadly. It's just, gosh.
I just expect my law enforcement, from judges to, feet on the street, beat cops, to be honest. And it doesn't feel very honest.
Yeah, and Keith,
just to put it simple,
Keith just said if they hadn't waived the speedy trial, Anne would have won.
I agree 100%.
Yep.
They should not have waived that speedy trial. But, one thing I will say is the prosecution, they played a good hand making it seem like they had a whole bunch against Bryan Kohberger. And what's interesting is I don't think the defense team felt confident in Bryan Kohberger's innocence at that time, because the presentation, the statements that were being made, all that stuff was different at that time.
Yeah. And
so
one thing is, now that is a good transition for Anne keeps saying she believes Bryan's innocent now.
Yeah.
Did you know that's against like the bar's rules?
Of what?
I don't know if it's the bar, actually. Hold on.
I'm confused what you mean by that. I don't think
it's against some standards.
So what? They're not allowed to give their opinion?
No. So
what?
It's highly frowned upon by.
Okay, but that's not against the rules.
So it's a policy. So it's not like a rule. It's not like you can get in trouble unless you're lying, unless like you get proven to lie. Like, say you were texting somebody you thought Bryan Kohberger was guilty, and then you were coming to court and saying he was innocent, and then those texts were outed. Like, obviously that could get you in trouble.
Yeah,
but there's some kind of rule I saw being talked about on a show recently, where attorneys, there's some kind of policy and I'm trying to look it up real quick because I can't remember what it's called off the top of my head, that defense attorneys are not supposed to say that. They're not supposed to voice that.
I don't know if I believe that. I don't believe that.
What do you mean?
I just don't believe that. That doesn't matter. They're there to defend their client. And
what do you mean
to
you
be
don't
like,
believe
hey,
that?
you're not allowed to voice that you have an opinion. That just doesn't feel like an actual rule.
I need to find it.
Because what does that matter? That doesn't do anything. As the defense attorney, you're already assumed to believe your client, even though, you know, they don't or do, or it doesn't matter. I would just be curious to see where it says that, like an actual, you got to remember, you got to look up state. Maybe it's a federal thing. I don't know. But it's worth looking into. It's definitely worth checking out. And
It's true. I know that there is a policy. I just am not sure exactly where it was. I saw it being stated by, I think it was a lawyer, maybe on Court TV. I'm trying to remember exactly where it was so that I can figure out where it was. I should have had it pulled up before I even brought it up. But anyway, I can pull it up for later when we go live later, because I'll have to like sit here and be in the computer and not talking, looking it up to be able to find it.
Yeah.
So, yes, I saw it on, it was mainstream media. There was some lawyer, I believe, that came on that said that she's not, like, they're not supposed to say that.
Okay, but there's
technically there's a policy. Now, does policy mean that they can get in trouble for it? No, but it can be seen as unprofessional.
Okay, but you've got to be clear about that, because again,
I am being clear by saying that.
I know. You got to remember, I'm the type of person that doesn't respect rules like that. I would not follow that. Either you're telling me I'm allowed to do something or I'm not. Very black and white. Somebody saying, I guess you can, but it's frowned upon. It makes you look really bad. I'm going to do it just because of that.
Yeah,
that's not breaking a rule.
Yeah, but
that's like those. That's like the stupid IGG.
But there's professional conduct expectations of what is professional conduct. So you don't hold yourself in a professional way at work?
What do you mean?
Like, that's considered unprofessional.
No.
It's conduct that is considered unprofessional.
What's professional is offering your client and the state the respect it deserves, not your opinion. Nobody is allowed to say that your opinion is unprofessional. I just don't see that. I just don't agree with it. And again, it goes to the IGG rules that we've covered. Like, hey, these are just guidelines. It doesn't mean you actually have to do it. Okay, that's better served in my bathroom as cleaning paper, you know?
I understand your argument. If there's no accountability for it, then it's technically not a rule and there's no reason to follow it.
Exactly.
I understand that point. But there's also things that can make you appear as not professional and people don't respect you in your industry, and things that if you conduct yourself this way, people will respect you and consider you professional.
But respect is a personal choice. Someone else can't be like, if you do this, it's not against the rules, but everybody is going to equally disrespect or not respect you anymore. That's silly. That's why I'm saying, like, it with rules, unfortunately, in this situation, I feel like it's got to be black or white. Like, either you're allowed to do something and get off my back, or say I'm not allowed to, and this is my punishment if I choose to.
Yeah, it's just not how a court of law works. They have so many policies that are loose like that.
Dude, yeah, right. Yeah, right. There's a reason why expensive attorneys win.
What does that have to do with anything?
Because I don't think they get caught up and held back on these weird social expected, unprofessionally suggestive rules.
You just proved my point of what I said, that there's these policies and things in place in the judicial, in court, and with lawyers
that the most successful lawyers don't follow.
I never said that.
No, I'm saying that.
Okay, you're saying that. But I'm saying that a lot of them are flexible. Like, not everyone follows them, but some people do. But if you don't follow them, it can later be brought up if you do something wrong to make your character look even worse.
Sure. Yeah. Okay.
Like, look, this person doesn't follow any of these policies. They're extremely unprofessional and they did this wrong, and it can look really bad on you in the end.
Yeah. I get that it could be brought up and used as, like, you know, ammo or fodder against you, but again, I think that's a personal choice.
And I'm not calling out Ann Taylor like I think she's doing anything wrong, because I don't necessarily believe that should be a policy. I don't know. Like, I don't know how I feel about it. I think that if there's no accountability to be had, if she can't get in trouble for it, then it's really not that big of a deal. And I find it interesting that they're, you know, her and Masseth and, you know, they've staked their claim on Bryan's innocent, and they've done it loud and proud the past few hearings. I find that interesting, because I think that's a risk, saying that. And I don't know that they would take that risk.
I don't think it's a risk. I don't. Listen,
I do. I think it's a risk.
I am a huge advocate for absolute and total freedom of speech when it comes to opinions and our perception on situations, and to act like it's against policy for a lawyer to share their opinion with the court is absurd. That is absolutely absurd. That's the most ridiculous thing I've ever heard in my life. Now, if you're going to argue that that opinion is being used to intentionally bias others' opinions, okay, let's look at the evidence and look at that possibility. But if it's just their opinion, what? I don't know. I just don't see it, you know?
Yeah, I don't even know what's necessarily wrong with a lawyer saying that their client's innocent, unless they are worried about biasing the jury, unless they are concerned that it will be used as a tool in court, to bias the jury. Like, I think that is probably the concern, honestly. If I'm thinking about any of the issues with that, I think it would be that. But you know, it almost feels like it's not fair, because the state is allowed to say they believe Bryan is guilty.
I mean, I think the defense is too. I don't see that as breaking rules, me personally.
It just doesn't feel fair. I'm not saying I disagree with it. I'm just saying I heard that it was a policy.
Yeah, I got you. I just need to see it, because I'm just doubting it is all.
I'm not making it up.
Yeah, it has nothing. Listen, you can't get offended at me questioning that. There are a million different rules set that you have to follow. Is this a federal suggestion? Is this a state suggestion? Does this have to do with civil court? Does this have to do with criminal court? Like, there's too much here that could possibly be the reason for saying, you know, don't give your opinion. It has nothing to do with what you're saying. I'm just saying I doubt it. I don't believe it's that simple. I don't think there's any policy that is an umbrella policy that says lawyers are not allowed to say whether they believe somebody is innocent or believe somebody is guilty. That's just silly.
Okay, it's called a code of ethics. Okay. I'll look it up and we'll pull it up tonight.
Yeah.
Because I don't think it matters if you feel like it's silly. If it's a thing, it's a thing, you know?
Yeah, I agree. But I think that I have enough faith in our court system that I would like to, like, we make decisions and rules and laws with reasons behind them. You know what I mean?
Yeah. And I mean, Hiroshima, you're right. If Ann Taylor is saying she firmly believes Bryan Kohberger is innocent, that is supposed to mean she has evidence backing it up and that she actually believes it.
Yeah.
And if that's not the case, then she can get in trouble.
Yes.
Because that's perjury. You're not supposed to lie. So I've seen numerous people ask for a show going over the PCA again.
Okay.
I mean, we will be on tonight.
We read the whole PCA, you guys literally read it straight on one of our episodes. I'll have to find it. I don't know where it is, but I know a lot of people have referenced that. Hang on one second here.
We read it straight. We didn't talk about opinions or analyze it or anything. It's reading it.
Mm-hmm. Yeah, just so people have the ability to reference back to it. Hang on. All right, here we go. Let's see here. That's PCA visual timeline. I'm not sure here.
Yeah, and I think that's right. The defense and the prosecution are considered biased, and that's why the judge is meant to remain unbiased. It's the point of the system. That's right. Yeah, I mean, so Tina said if the PCA is false and manipulated, the case should be dropped. I understand that argument. I understand it. However, we're so far into this now, and there's so much behind it. Tina, I just think I don't think there's a way out. I think we have to go to trial. You know, they fought to try to get the indictment overturned, the grand jury indictment, to try to get this to go back to a preliminary hearing, and nobody was having it. You know, the Supreme Court wasn't having it. The judge wasn't having it. So since that was all denied and rejected, and I think that they knew some of these issues were issues back then too. I mean, because clearly they didn't have a cast report. They didn't have the IgG information. You know, there was a lot they didn't have and still don't have.
Mm-hmm.
And still that indictment went through, and still the judge did not agree to send it back to a preliminary hearing and overturn the indictment. So I just think since we're past that now, since we're way past that decision, there's just no way that they could drop it.
Okay, I am posting this.
Won't happen, unfortunately.
In here now.
I get it. Where are Bryan's rights? I don't know, but we haven't seen all the evidence yet. Even now, we haven't seen it. We just know there's issues.
So it is this one right here. It is this one right here for those of you visual watchers that are on all the other platforms, which we have like a ton
shared the
of people.
link?
Yeah, I shared the link. We have a ton of people on here, like a ton of people. Okay, so yeah, it's this one right here, and it is a straight read through of the PCA. Now we can still do another one. I'm not against that, doing some updates. Sometimes it helps to understand cases a little bit better by looking back at some of that documentation and other things. So but yeah, it's interesting for sure. Oh man, we're getting a lot of marketing dollars on this video, trying to round the views down. I just thought this was huge. Like this case was this hearing was massive, you guys. And what I mean by that is, like, I just keep hoping every hearing that we watch that something is going to break and we're going to get honesty, right? I think that this whole case has been brought up with the intention of being able to control the public perception. That is not what we want to see in our judicial system. I do not, unfortunately, for most people, think that the FBI is the reason here. I think that This is, for whatever reason, a small town mindset in this area when it comes to law enforcement, not the people, but how law enforcement has been able to function in this area. And as a result of that, I think that we see situations like this, where you have a prosecutor who doesn't even know how to act when he doesn't get his way, right? Now that the whole world is watching, they actually have to button up that shirt, put a tie on, and be honest, which is how the foundation of our judicial system was built. And it's just absurd because, again, you guys, I know me arguing the semantics in the court and using it against the prosecution and the investigators makes it look like I am for Bryan Kohberger as being innocent. And I am arguing this because it is an equally big problem if Bryan Kohberger is guilty. If Bryan Kohberger is a guilty man and the Idaho, the ISP, Moscow PD, and prosecutors are using manipulative tactics to try and convict him, then we risk letting a madman out, okay? There is no situation where bringing manipulative evidence and exploited evidence to the table is acceptable. It doesn't matter if the defendant's guilty. It doesn't matter if the defendant's innocent. Using manipulated and twisted evidence is wrong, and it serves nobody. It doesn't serve anybody at all. Let me see. I know we briefly talked on this. I want to bring that up again, though, is that the idea that Judge is like, hey, this case is so in-depth and so hard, and there's so many moving pieces to it that, you know, I'm not willing to just have an open hearing and because all of this evidence is similar to the IGG, and we need to go through it first before we let the public in on it. That's a major problem. And I feel like that Judge has been really good up until this point about having the back of the judicial system and the people that are interested in this case. There's nothing they can do to make this not in the public's eye. This case is in the public's eye, period, point blank. And it's not ever going out of the public's eye all the way until the end. So to try and now hide it from the public is only going to hurt the situation more. It's only going to make people doubt the reliability of the investigators. It's going to make people doubt the reliability of the prosecution. It's going to make people doubt the reliability of the state. And to be honest, I'm really surprised that the victims' families have supported the prosecution this long. I think there are problems here, and I think the prosecution, I don't know if Bill Thompson is necessarily to blame, you guys. I'm just using them because they're the ones presenting on this evidence. However, I think it's very possible, and we've said this quite a few times, that Bill Thompson could have been handed a giant pile of doo-doo, you guys. Like, here's the evidence, you know, and it's all manipulated, it's all fabricated, it's all twisted, it's all unfounded. There's nothing to lean on to support this evidence and claims that have been handed to Bill Thompson. And Bill Thompson could be scared right now. He could absolutely be scared for his career because in a case this big, the presentation of the prosecutor and the defense attorney are going to be what their career is for the next whoever knows how long. And I think Bill Thompson could be scared. Now, in that situation where he got handed a giant pile of doo-doo, there's not much you can do. It puts prosecutors in a very, very, very uncomfortable situation where they essentially have to call out their peer counterparts or figure out or move forward with an unfounded case or find some kind of other resolution. And I just wonder if we're seeing such uncomfortability from Bill Thompson right now because of that. Because he's looking at this case and going, oh my gosh, what am I going to do here? What what am I going to do? Am I just going to go in court at the next hearing and be like, hey, judge, let's just throw this out and hand Bryan Kohberger the keys because this evidence sucks and there's nothing to back any of these evidence and claims that are in the PCA? That's just not an option, you guys. It's going to fall on, it's going to tank probably Thompson's career. Somebody's going to have to be the fall guy. It's going to tank Fry's possible becoming sheriff's campaign. It's going to make everyone look bad, man. Everybody, not to mention the eyewitnesses. What's going to happen in that situation if this were to happen? Like, the implications of coming out and saying, hey, we messed up, sorry, are just too great. They're great. Too great. So it's definitely interesting. And I despise the fact that they paired all this evidence in with the IGG and was like, well, you know, it's just as confusing as the IGG. So I think we need to close this hearing. Get out of here. Get out of here. I look at court in the same way that I look at the ownership of data. Okay. So we own our data. What that means is, like, when you're on your phone and you're searching Google and you're searching YouTube, those searches are data. Okay. And that data is saved somewhere. And you own that. You own that because you typed it. It came out of your head and it's yours. Okay. Well, data brokers buy that data to learn marketing techniques and manipulative techniques. And it's just part of, you know, corporate America, whatever. It's been legally officiated that we own that data. Okay. And you have to confirm with a little pop-up box. Can we use your data? Yes or no, whatever. Well, court, in my opinion, is the same way. The evidence that is Bryan Kohberger and being used against Bryan Kohberger, in my opinion, is his. Shouldn't he have the say on that, of whether it's allowed to be seen? Well, obviously not used, but seen, presented, or talked on out in an open public setting?
Yeah, I think that Bryan, it's his right. I think that it should be respected. I think it's up to him. The majority of the decision lies on him of if he wants it to be open to the public or not. So I think denying him that right is kind of messed up. And I think that the judge only made this decision to protect the state's reputation. And I think that's problematic. So, you know, I'm disappointed that he closed it, but, you know, he did say there's the possibility of opening it up once they've gotten through some things, whatever the heck that means. So we'll see what happens. We'll see what happens. So are we going to go live tonight still, or are we going to skip tonight?
No, I don't see why not.
Okay.
I don't know. I guess we can figure that out after.
Okay.
But yeah, no, I agree with you. And I think that gives us the ability to figure out, you know, and kind of chew on this a little bit and then kind of go from there. But, yeah, anyways, I'm super happy that you guys were all here with us. And, you know, I think this was an eye-opening situation and hearing. And I guess we're going to keep watching to see what happens next in this circus.
Yeah, and I'm honestly, I love having the community of thought rioters to watch these hearings with. Like, he's seeing everybody's reactions, hearing everybody's opinion. It's really, really nice having you guys in the chat, watching through it, reacting through it. It's really a good time. You know, I don't know. It feels like a support group.
Right.
While we're watching this just circus, you know, it's so like I'm invested. So it's partially stressful.
Yeah.
You know what I mean?
Yeah.
I want justice for the victims. I want, if Bryan's innocent, I don't want him to be convicted. You know, I want the best outcome for everybody involved. But yeah, thank you guys for tuning in today and watching the hearing with us. If you guys are just hopping on, you can catch the replay. It was quite an interesting hearing. And, you
Mhm.
know, subscribe, turn on notifications so you can be notified next time we go live. We're on all social medias. Come check us out on Twitter or X at Thought Riot Pod. Join the Discord. And, you know, we're on all podcast platforms, all social
Yeah.
medias. Stay up to date with us.
Yep,
And-
absolutely. And we will see you back here tonight. Hit that thumbs up button, leave a comment under the video, you guys, no matter what platform you're on. It helps us get out there and get seen and get heard. So thank you, Thought Rioters, and we will see you on the next one.
Bye.